We're all rising.
Oyez, oyez, oyez. Anyone having business before the King's Justice of the Superior Court of Justice, attend and shall be heard. With the King's starting, you may be seated.
Good morning, all.
Good
Good morning, Professor.
Good morning. I think I'll just briefly recap where we left off, which was the Supreme Court and then the Judicial Committee of the Privy Council determined that the increases of the annuities up to $4 per person were to be treated as a debt of the province of Canada. It would therefore be the responsibility of the Dominion and later then to be recouped from Ontario and Quebec through Section 112 of the BNA Act. Then we went back to the arbitrators, and the arbitrators issued their 10th award confirming that decision, where the 10th award is in your report at page 224. The 10th award said that the contingent obligation devolving upon the Dominion of Canada to pay the increased annuities mentioned in the treaties and any increased annuities which have become due to the Indians since 1892 shall be taken into account and included in the debt of the province of Canada. So then,
You say that's a summary of yesterday's evidence.
yes,
Maybe you should get the witness to adopt that.
Yes, I would concur. That is correct.
thank you. So then we're back now in front of the arbitrators. And we're in this section now called negotiated resolution.
Yes.
And on page 262 of your slide deck, this is your negotiated resolution section.
Yes.
And here you've sort of jumped ahead to award 15.
Yes.
And can you perhaps tell us what award 15 has to do with this negotiated resolution? Because you later deal with award 15. So you
Yes,
seem to be
yes, I do.
introducing it here sort of to provide some context, I guess, for the negotiations.
Yes.
Can you explain that?
Yeah, the negotiations were ultimately reflected in Award 15. There's a few things I might say kind of overall about Award 15 at the beginning. One being first off that it was a reflection of negotiations. It wasn't so much the arbitrators imposing an award as it was the arbitrators writing up an award that reflected what the three parties, the Dominion, Ontario, and Quebec, had among themselves agreed to over a process of several months of communication. That's, I think, an important point about Award 15, that it was a reflection of a negotiation. They didn't so much impose it themselves, the arbitrators. The other point, I guess, really ought to be said is that no, none of the Indigenous parties were party to these negotiations. They were only between Ontario, Quebec, and the Dominion. Another point that I think is important, and I'll ask Your Honor's forbearance if at times I do need to refer specifically to documents, and that is that this increased annuity payment was only ever discussed in terms of not to exceed $4 per individual. There was no contemplation that I have found at any point in these discussions that culminated in Award 15 that higher amounts might be payable. So what the three parties did in the process leading up to Award 15 was agree on statements that showed the revenues from the treaty territories, that showed the expenditures in the treaty territories, and that showed ultimately which years was there an excess of revenues over expenditures that would permit payment up to $4 per person. Well, I shouldn't put it that way, because payments up to $4 per person were already being made. But what I would mean there is years in which the province of Canada could with justice be asked to recoup the Dominion for those $4 payments that were already being made. Is that, have I made that clear?
Just a tiny bit confusing.
Okay, sorry, I should maybe state that a different way, that after it was agreed by all parties in 1874 that the annuitants were entitled to payments up to $4 per person, then payments commenced. And at this point, with Award 15, what was being worked out is, did the revenues and expenditures indeed justify, based upon excess of revenue over expenses, did they justify that $4 per person payment? And the agreement that we'll get into here is that during the years that such payments were justified by the yield of the territories, then the Dominion would be entitled to recoup from the provinces that amount that they had already paid. And I hope, Your Honor, that it will become clear as I go through the specifics of it, which I would like to do.
So just that, and it's, you
Mhm.
probably know this inconsistency, but you say the decision was, or the agreement was, that the annuitants were entitled.
Yes,
And then they looked at whether the revenues over expenses justified
yes.
$4. So what was their thinking when they decided they were entitled, just without having looked at the numbers?
Essentially, yes.
Okay.
Yes, that in 1874, we have Oliver Mowat in Ontario, we have Edward Blake, the federal minister of justice. We have various parties agreeing, oh yes, they're certainly entitled to these increased payments. And then I suppose when they looked at the numbers and looked at the list of expenditures that were agreed could be deducted, then they found that in some cases, not every year did yield sufficient net revenue that would apparently justify that $4 payment.
And only for those years that did yield it, would there be a chart? What do you have it? Then
Yeah.
the Dominion would be entitled to recoup.
Correct, yeah.
Can you just remind us in that vein, Professor Messamore, about some of the arguments that A.M. Ross had been making on behalf of Ontario?
Yeah, there were a number of them. I mean, his argument was that we shouldn't be required to pay anything prior to a demand being made. Ross's position was that it was only in 1873 that we became aware of these complaints of inadequate payment. That I suggest was his understanding. I don't think it was an accurate understanding. There was also, yes, no, I'm sorry, an accurate understanding, yeah. There was also questions about who ought to be entitled to payment, and he made inquiries about that. Were these descendants of the original? Yeah, yeah, there are a number of scores on which he questioned.
Okay. I think then we can move on with that background.
Yes.
To going through your slides then. So did you want to start on slide 263?
Yes, that's where it would be appropriate to start. So I mentioned statements. Statements were compiled in May 1898. of revenues and expenditures in the treaty territories. There was one statement for the Superior Treaty for both these things, expenditure and revenues between 1850 and 1892. And I would point out that they used 1892 because that was the date of the commencement of arbitration. And so that was the scope of what the arbiters were tasked with
Thank you.
ruling on. So one statement for Superior, another statement for Huron, and these statements were signed off by representatives on Ontario, the Dominion, and Quebec. So Irving for Ontario, Hogg for the Dominion, Trenhold for Quebec.
So on page 264, you talk about these two tentative statements, and I take it there's two because one has to do with the Huron Treaty.
Yes, yes, that's correct. So these show the amount for which the two, the amounts for which Ontario and Quebec would be conjointly liable for the increase in annuities in certain years between 1850 and 1892, one for Superior, one for Huron. And so essentially this was a calculation of the years in which there was an excess that
Okay.
would permit this payment.
So I should note that if anyone wants to look at those statements, they are included in the compendium at tab 21. But I think for our purposes here, Professor Messamore, we don't need to get into the numbers. We can probably just jump down to slide 265.
Yes, so our point here is simply that for Huron territory, the first year in which there was an amount in excess of progressive expenditures was 1873. And it showed calculations again using $4 as the basis.
Thank you.
I'm
Sorry.
Oh, sorry. And that there were a total of 14 years for the Huron Treaty in which there was an excess that would permit.
And I'm just
payment without loss.
rushing you along to get to
Of
the
course,
Superior Treaty, which
yes,
is of
that's
more
266.
import for our purposes at slide 266. Perhaps you
Yes.
can take us through the statement for the Superior Treaty.
Yeah, so the equivalent statement for Superior shows amounts for excess of of collections in excuse me, in the years 1853, 1854, 1856, 1857, 1872, 1873, and 1874. So that 1874 proved to be for Superior the last year in which they showed an excess of collections.
And by you use the word collections interchangeably with revenues.
Yeah, I'm sorry. Yeah, collections is the word I think that they use. So yeah, it's probably revenues would be a better term to use. Yeah.
And here I think we're talking about net revenues because they've taken into account.
Yes,
expenses.
that's correct. Yeah, yeah. So
Sorry,
Revenue.
net or gross? It says collections in excess of expenditures.
That
yeah.
means,
so ultimately arriving at net revenues, if we talk
Net
about
revenues.
starting with
But
the revenues.
collections would have been gross revenue.
Yes, you're correct. Yes.
Okay.
And so that's 1, 2, 3, 4, 5, 6, 7 years for Lake Superior. And again, this is based upon $4 per annuitant. So on slide 267, if we may, I just observed that the apparent finding that the Superior Treaty had not, in fact, produced sufficient net revenue after 1874 to permit an increased annuity payment without incurring loss introduces another dimension to this already complex history. And that is because they were, since 1875, had been paid $4 per person, based on the understanding, as Your Honor referenced a moment ago, that there had indeed been sufficient revenues to permit that, those payments.
Can I go back to slide 266? The very last point you say for this treaty too, there were calculations up to the amount of $4.
Yes,
And that calculation is for the purpose of understanding or dealing with the phrase not incurring loss, but not for calculating the amount of the treaty, or for calculating the amount of the increase, was it? Or do we know?
sorry, I just want to make sure I understand the question. Maybe I should explain as I understand it, and if it's unclear, I'll answer any further questions about it. But
I don't understand the question either.
Okay, so what were they calculating? This line says
yes.
there were calculations up to the amount of $4.
okay, what I understand here is that the amount, the maximum amount that was contemplated was $4 per person in these calculations. So they showed revenue, they showed expenditure, they showed what it would cost to pay annuities up to $4 per person. Given those revenues and expenditures, could that $4 per person, or could the payment be increased to $4 per person without incurring a loss?
So that's what the purpose of the calculation was.
Yes,
There
exactly.
was no
And-
sharing calculation.
Not at this stage. Sharing, you mean between the Dominion and the provinces, or sharing of revenues over and above?
Over and above expenses.
Sharing.
Sharing
With
of
who?
resource.
So they looked at all the revenues in the territory.
Mhm.
They looked at all the expenses.
Yes,
They made a calculation,
yes,
revenues minus expenses, and they came up with net revenues.
yes.
Then what I understand you to say is, then they looked at paying everyone $4
Yes,
to see if they could pay them $4 without incurring a loss.
that's correct.
But what they didn't look at was the net revenues and say, how should we share this
I
as
understand.
between, who's ever doing this, the Dominion and the annuitants?
So you mean the idea of such further sum over and above the
Mm.
$4?
I just don't,
No.
I'm just working with what you're
Yeah.
telling me.
Okay,
It was a calculation
yes. That only went to $4. It was
up
no,
to the amount of $4, but that calculation, I'm guessing from what you say, is that they took the total net revenues,
Mhm.
calculated how much it would cost to pay annuitants $4 each.
Mhm.
And from that concluded that they could do that without incurring loss
Yeah, in certain years, yes.
in certain years.
Mhm.
Is that your understanding?
It,
Or is that,
it was all in certain years. They calculated
In
in which
certain years.
years was their net revenues.
yes, Mike, what I just described was in any particular year.
Mhm.
Is that what they did?
When they took those, if there was a year in which there was net revenues,
Yes,
then they would increase the annuity to $4.
from the pool of net revenues.
I don't think there's any evidence of that.
Okay. Okay, so there you go. So I would say, I don't understand what that means.
A moment. A lot of this will become clear in argument, I think. I wonder whether it also might help put this in context. We skipped over Professor Messamore at page 266, your point about the base payment amount, which at that point was $2.39 per person. Is it possible for you to describe for us what you mean by the base payment amount?
Okay, I'm
Remind,
actually at this point not confident that it was at that point $2.39 per person. I think it
Okay.
might indeed have been lower.
Okay. It's-
So, yeah,
That's all right. I think we answered Justice Hennessy's question, which was, well, maybe we didn't actually.
if-
You wanted to know if exactly where the funds came from, I suppose.
Not so much where they came from. I'm just trying to figure out. There were calculations. What was involved in those calculations?
Why don't we look at them? Because I've got them here at tab 21 of the compendium.
If I can comment, I think what I understood when you mentioned sharing, Your Honor, is that I thought perhaps your question spoke to the issue of if the revenues had been very significant, would they have gone beyond the $4, or is that not what
Well,
you intended to
I'm
ask?
not asking what they would have done.
Uh-huh.
I'm asking what you mean by there were calculations. So what's involved in those calculations?
Let's look at them. They're in
Okay.
tab 21 of the
20.
compendium,
Yeah,
Mhm.
and they're on the screen before us.
okay.
So I'll read it then if you'd like.
Please go ahead.
A tentative statement of the periods when Ontario and Quebec become conjointly liable to pay increased Indian annuities by the Lake Superior Treaty. The sums estimated to be payable at such periods are set down in red ink in column 4. The numbers of Indians assumed to be paid are in accordance with Dominion allegations of payments. I think what that really means is the Dominion counting of the Indigenous people who are entitled, and are subject to proof that such Indians are entitled to the increases. So in each column, the first column we have the year. The next column we have amount of collections of progressive. The amount of collections in excess of progressive expenditure at periods when the Indians can be paid without incurring loss. And
So what I'm think is possibly dealing with my question is when the Indians can be paid. So there is money in excess of expenditures, and that excess triggers the payment.
That's correct.
And that payment can only come from that excess. Like it can't be over that excess, otherwise there would be loss. Is that what I'm understanding? That's what the calculation is. Can we do this without incurring loss?
Well, I think that the calculation, we'll ask Professor Messamore if she can shed any light on this, but
That was my understanding, that the criteria was without incurring loss. But, as I said, it's complicated by the fact that payments had indeed already commenced, just based on an understanding.
and isn't the purpose of this calculation was to determine how many years, for which years,
Yes.
were there sufficient revenues that the Dominion could convince Ontario? I don't want to put this in my own words. It's not
Okay.
No.
Yeah,
appropriate.
no. Yeah.
I think I'd just like to move on if we can. Are you content to do
Yes.
that? I think because
Okay.
as Professor Messamore will explain that this statement is only one piece of the puzzle, which I think will become clearer as we move through.
Well, I think we're actually
I don't want to
page-
place too much importance on these statements
Okay.
because they're tentative statements that,
And they have a purpose. That's what I'm
Yes.
looking at, the purpose. So it's
Yes.
looking back, could they do this? They're looking at past.
Yeah, I think we're actually on to page, slide 268. And HOG, I explained, was acting for the Dominion. And he communicated with Ontario's counsel, Emilius Irving, on the 6th of April, 1899, to say that he understood that Irving wished to have some kind of order or direction of the arbitrators to say that the statements filed were to be conclusive and final as between the parties. And he's saying that he understands he should prepare some sort of order and put that before Irving and Trenholm for Quebec for approval. And then it would be formally signed, he said, by Mr. Justice Burbidge, who is one of the arbitrators in Award 15. So this is a reference to Ontario's wish to have a statement of finality attached to whatever conclusions were reached as to the calculations.
Thank you.
On the next slide, 269, Hogg informed Irving that he had drawn up such an order. And he's saying that you might think I've not been particular enough in referring to the statements. And if you think so, I will specify them more particularly. But the order itself is that the statements are to be final and conclusive against all parties to this arbitration. When you've considered this draft, he would get back to him.
So then Hogg writes another letter to Irving a couple days later that you discuss at slide 270.
Yes. This was, I thought, rather interesting because it speaks to the question of what the negotiators, Hogg, Irving, and Trenholm had in view when they were communicating. And Hogg wrote to Irving on the 10th of April, 1899, to say that he'd received a letter from Quebec's council to say that Trenholm, Quebec's council, has some notion that by consenting to the order, he might some way or other be committing Quebec to something more than the order specifies on its face. And he wished to have a clause saying that the consent wasn't to be understood as directly or indirectly having any other effect. And Hogg added in the same communication, if we can look at the slide that follows, I do not see.
Please,
I'm
please
sorry.
give the number for the.
Oh, I'm
record.
sorry, 271.
Thank you.
Slide 271. Hogg added, I do not see how the consent and order could have any effect upon Quebec in any other matter than that referred to in the order. But he seems willing to add such a clause.
Thank you. So then on page 272, Hogg writes to McLean, who's the secretary in the Department of Indian Affairs, and explains the negotiations. Can you take us through that slide 272 as it relates to the Superior Treaty?
Yes, I just note here that Hogg's saying that a settlement has been practically arranged between Ontario, Quebec, and the Dominion about the number of years in which increased annuities were warranted. And he gives a total of 14 separate years in the case of the Huron Treaty. In the case of the Superior Treaty, he gives 6 years, 1853, 1854, 1858, 1872, 1873, and 1874. And I just observed here that the Huron dates are consistent with the tentative statements of a few weeks before, on the 23rd of March, 1899. But in fact, there's a difference in the sorry, in the Superior Treaties. I'm just looking here. 1, 2, 3, 4, 6, 7. Yes. So in the Superior Treaties, this represents now only 6 years as opposed to 7 that were originally listed. And there's slight difference in those years. May I go to the next slide, 273? Hogg also wrote to McLean, the secretary in the Department of Indian Affairs, that the provinces had practically agreed to the statements.
Sorry, does practically mean almost?
I think it means that they
They've
have
done the
essentially
work.
agreed. Yeah, I mean, it's difficult to say, but I feel like, I mean, this is a negotiation, so there is, I think, still ongoing discussion of a couple of things that were in dispute. One, sorry.
I just wanted to interrupt, make sure we start with the beginning of this quote.
Oh, yes, yeah. Yeah, of course, I was going to come to that point. As to the number of Indians,
Right.
the provinces have practically agreed. So that's one of the questions in contention, is how many annuitants would be entitled to payment. The result was that for the Huron Treaty, those 14 years would require, according to these calculations, the sum of $95,768 to be charged against the province of Canada for those payments that had already been made, and for the Superior Treaty, the sum of $17,232, which again is, as a reminder, was only the calculation going up to 1892, but in point of fact, the years in which a payment was deemed to be triggered by the excessive revenue, the last year was 1874.
Thank you for that. Can I just ask you,
yeah.
what relationship does the population, the number of Indians, have to do with these numbers? And let's just take the 17,000 with respect to the Superior Treaty. Why is he talking about as to the number of Indians? Is this an important part in helping us arrive at that figure of 17,000?
Yes, I believe it is, because it's based upon $4 per individual. And so there has to be an agreed population figure that would allow that calculation. There is one other important point in this slide, and that is that it was beyond the scope of the arbitration to think about capitalization for future. They were only concerned with what had been paid up to 1892 and what amount, if any, should the Dominion be paid back by the province of Canada. But Irving, as counsel for Ontario, said he wanted to make his consent to these figures conditional on a capitalization agreement for the future after 1892. So that hadn't been part of the scope of the arbitration, but Irving says that he wants to have certainty about the question and to have this amount fixed so the case can be brought to a close and finally disposed of, which he understands would be the case if capitalization for after 1892 is also part of their negotiations.
Because Irving makes it part of the negotiation.
Yes, essentially he does. Yes. Yeah. And I think that my sense, and again, I don't know this, but I feel that this fits with what the Dominion would have probably preferred to do, because they'd always capitalized annuities in the past.
Thank you. So that takes
yeah.
us, I think, to slide 274.
Yes, and again,
And I think this is fairly important. So if you want to go through that.
yeah, I
That's
think perhaps if I can ask your honor's forbearance, that I'd like to kind of deal fairly closely with the language here.
Go ahead.
So Hogg, in writing to McLean on the 3rd of May, says that in Duncan Campbell Scott's report, of the 22nd of February, 1899 on this subject. He suggests that for the future after 1892, the number of 2,800 might be properly fixed as the limit beyond which in the Huron Treaty, the responsibility of Ontario and Quebec jointly should not go. This number would involve an annual payment by Ontario and Quebec of 8,800 over and above the interest of the amount already capitalized.
Can I stop you there to sort of explain what he means by that?
Yes, I think he means that, again, working, okay, thinking about capitalization in the future after 1892, that they might do it on the basis of 2,800 annuitants and set that as the cap, that for the amount of $4 per person that Ontario and Quebec are agreeing that they would accept that number and accept a capitalization of payments of 2,800 people at $4 each.
Is this both treaty
No, in
territories?
fact, because it was understood that the Superior Treaty, or I should say understood, it was believed that the Superior Treaty would not yield sufficient revenue to warrant a payment. They only saw the need to capitalize for the Huron Treaty for future, because the
But
the
I'm
Superior,
just asking about these numbers for a moment.
oh, I'm
these-
sorry.
These populations.
I think that this would be for the Huron Treaty alone.
Thank you.
Because they would have no reason to believe that they would be paying superior annuitants. And then Hogg also refers to the desire, oh yes, here's the point, of both the provinces and the Dominion, that instead of having an annual sum payable by the provinces to the Dominion to make good the increased annuities, the annual sum should be capitalized and the province of Canada account charged with the amount of the capitalization as was done in 1867 with reference to the fixed annuities. And so he said if the annual payment is taken at $8,800, that would be the sum to be capitalized.
If we move on to the next slide, 275.
275.
That first paragraph deals with the percentage at which it would be capitalized, which I think for present purposes, we can skip over because you summarize it later.
Yes.
But the second point you may make on that slide is important. So maybe you could take us through that.
Yes, and this is with reference to the question Your Honor asked a moment ago. Hogg says that I should say that the capitalization has reference only to the Huron Treaty and not to the Superior Treaty. In the case of the latter treaty after 1874, the expenditure has been greater than the revenue, and the balance has been on the wrong side since that date. And so far as I've been able to ascertain, is likely to continue for many more years to come, so that in the Superior Treaty, the question of capitalization must be left out altogether.
Can I
Thank you.
interrupt you here to ask? So it seems that Hogg, on behalf of the Dominion, is suggesting we don't need to worry about collecting from Ontario and Quebec an amount to enable us to pay $4 per person in the future, because
In the
the-
Superior region, in the Superior territory.
in the Superior Territory,
Yes.
because we don't imagine there will be sufficient revenues to warrant the increase to $4.
That's correct.
But at the same time, the Dominion is already paying $4 per person to the Superior Treaty annuitants.
Yes,
Isn't
they
that
are. Should we move on to slide 276?
Yes.
So Hogg says that his object in writing to Maclean is to have his views on the subject of capitalization, because he says the provinces are anxious not only to have the subject matter, which is immediately under the jurisdiction of the arbitrators, brought to a close, but to have all outstanding matters related to these treaties finally disposed of. So what he means there is that the arbitration has been tasked with considering events up to 1892. And he said the provinces are eager to have that, not only that disposed, but also the future after 1892 settled. And then there's discussion about the numbers and the capitalization. And this seems to be a matter in both cases of negotiation. And Hogg seems to be suggesting that he's willing to perhaps consider those 2 points of contention together. You might say that he would have preferred a lower capitalization rate. He says that interest rates are now lower if we capitalize it at 3%. That's a more accurate reflection of the current cost of money, I suppose. The provinces would have preferred a higher rate because that would require a smaller sum of money to be capitalized. And so that question of the rate of interest to be used for any capitalization is also part of the negotiation, as is the number of annuitants that we're going to agree upon.
And
Mhm.
should we assume, or are you going to get to what Canada is using as a population basis for their payments at
Yes.
$4?
Sorry, I think we are going to get to that point.
In
Yeah.
fact, I think, is it not covered in the second paragraph there?
Oh, yes, I'm sorry, you're quite right. It is. Yeah, I didn't
Do
read
you wanna
that
go
out.
through that
That's,
then? I think, yeah.
yeah, so I should say that it
And-
may be that the province will object to so high a number as 2,800 Indians. As I find for the 4 years commencing with 1895, the number has averaged about 3,360, from which is to be deducted 20%, leaving the average to be capitalized 2,688. It might therefore be fair to place the number of Indians for the purposes of capitalization at 2,650. And then he specifies what amount would have to be capitalized at 3% if that were the number.
Are those figures for Superior Territory?
No,
Or
they're
they're
not.
combined?
No, they're not.
Only for Huron.
These are only Huron numbers.
And can you
Yes.
explain, Professor Messamore, why are the figures for Superior not at all relevant here?
I
Because,
think
oh,
I asked that question and you gave it to me. That's,
Okay.
if I understand it, it's because they weren't foreseeing paying any annuities in the future.
yes, and so thus there would not have to be a capitalization process for Superior. Yes.
So I had that.
Okay,
Oh,
So
sorry,
my
sorry.
question was, on what basis was the Dominion, on what numbers was the Dominion paying $4 per capita?
that's a good question.
And so you
So-
say we got it right here, but
I understand your question now, and I'm sorry, Professor, or Justice Hennessy, because it's a very good one. And I was, Professor Messamore, although there's this discussion with Ontario and Quebec about what should be the number we use for the capitalization that you're going to pay to us, Ontario and Quebec. At the same time, the Dominion is paying $4 annuities to a certain population. What population number is the Dominion using when they pay those $4 annuities?
I'm afraid I can't tell you that in terms of what's being paid at this moment of that we're discussing here. Yeah, I mean, I understand that they would pay it to the actual population of those who were deemed to be legitimate members of those nations, Superior and Huron Treaty Territory nations.
Does that answer your
Um,
question, Justice Hennessy?
But in
if
terms of,
so they're paying it on actual populations, not the population in the treaty.
yes, that's correct. And I'm, as again, I don't know what that number actually is at any given year.
Actual
Yeah.
population,
Yes,
presumably on the basis of pay lists.
yes, I think so.
Okay, thank you.
Yeah.
So we see here, there's a bit of a disconnect because the Dominion is paying the actual population $4 per person. Is that right?
Yes, that's right.
But they're seeking capitalization from Ontario and Quebec based on a fixed and in fact, small, it would seem, population number.
Yes.
Is that right?
Yeah, I think that's accurate. I think I would describe this as a negotiation. And so it doesn't necessarily reflect the actual numbers. And of course, in the future, they don't know what the actual numbers will be. But I would describe it as a negotiated figure. And again, the negotiation included the interest rate for the capitalization as sort of another part of that equation.
Thank you.
In this letter, I'm sorry, if we can go to slide 277. Hogg's letter, again, implies his belief that the proposed transactions would put an end to the controversy. It does not betray any suggestion that any increased payments beyond $4 had been considered. And the same attitude seems to be reflected in his communications with Irving for Ontario about the concerns expressed by Quebec's council to ensure that his agreement as to the statements didn't imply any other commitment, any other unanticipated obligation. So I can't in this communication find any allusion to by Hogg to the possibility of augmented payments exceeding $4. I mention that because I think if we accept the premise that this communication was ultimately reflected in Award 15, I think it's important to understand when there's any ambiguity in the language of Award 15, what this agreement was meant to encompass. You know, and I've also repeated here Hogg's comment to Irving that he did not see how the consent and order could have any effect upon Quebec in any other matter than that referred to in the order. Could we go to?
Could you
I'm
just,
sorry,
on the top of that slide, you
Yeah.
say we'll put an end to the controversy.
Yeah.
What
yeah.
do you say is the controversy?
I guess the controversy being how much does the province of Canada, conjointly Ontario and Quebec, owe to the Dominion for these annuities?
Thank you.
Then we can turn to slide 278. And here this gets a little bit into the numbers, but I think it would probably be helpful to go through that, at least as it relates to the Lake Superior Treaty. Can you take us through that then, 278?
Yes, this is a communication from Irving to Hogg on the 9th of May, 1899, acknowledging Hogg's letter of the 2nd of May and establishing his clear understanding of the amounts to be charged to the Province of Canada account. He says, I understand you proposed to me that I should assent to the sum of $14,180 being charged in the Province of Canada account in respect of Lake Superior on the 31st of December, 1898 for the years, and he names them 5 years that figure represents. And he also says, he mentions a sum for Lake Huron. We can skip over that. He then says, again, in respect of Lake Superior to be charged in the Province of Canada account as of the 31st of December, 1874, the sum of $3,068. And again, there's a reference to Huron. And he says those figures, so far, when approved of by Ontario and consent given, would seem to close up the Province of Canada account in respect of these Indian annuities insofar as affected by the arbitration.
And this total between the 14,000 and the 3,000, for some reason they've set aside the 1874 number in a separate line item, but combined total of the 14,000 and the 3,000 represents the amount due for those 6 years.
Yes, that's
Which
correct.
would bring annuities paid in those 6 years up to $4 per person. Is that right?
Yes, yes, that's correct. So I give that total on a subsequent slide.
And in
but,
fact, we
yeah.
already saw that total on slide 273.
Yeah, I think 17,232, is that correct?
right.
Yeah.
Sorry, what is that, 17,000?
It's actually
17,000, it's on
No.
slide 273.
273.
Yeah, 273.
Yeah.
That's where you first see that figure there.
Yeah, except that this is a case where that isn't actually the sum of those two figures, but I don't want to get into that. It's very slightly different.
It's, I think, $16 more.
I don't have
Yeah.
a pen. Yeah, okay.
180 plus 68. It's 248. So we're on the slide on 278, the total would be 17,248. Whereas on slide 273, we had 17,232.
Yeah,
So we're
there is
just-
somewhere in my report where I note that that the sum is different. And again, I didn't kind of consider it within my realm to start investigating exactly why that was, but this is what Irving says here.
Can we move on then to slide 279? And I think that
Yeah, this
yeah,
is,
you might be able to, go ahead.
I'm sorry. Yeah, this is a continuation of Irving's communication with Hogg on the 9th of May, 1899. And I think one of the important things here, well, he repeats that Ontario is eager to have the whole matter adjusted, the acceptance of the number of Indians, the scheme of capitalization. Ontario wants those things together. He considered together, the province of Canada, or sorry, the province of Quebec. Irving is saying that he would like them provided with a draft order in council to be proposed to the three governments when Hogg submits his proposal for capitalization. And he essentially is asking Hogg to secure Quebec's agreement and to provide them with a draft order in council.
Thank you. That's securing Quebec's agreement to this concept of capitalization, is that right?
Yes,
Thank
yes.
you. All right, so that takes us to slide 280. And here we see that total again, although we're back to the $16 less.
Mhm.
But can you take us through slide 80 then, or 280? Sorry.
Yes, so that is a communication from Hogg to Irving on the 22nd of May, 1899. It includes calculations for amounts and years, indicating the charges to be made to the province of Canada account. There's a breakdown for both the Superior and the Huron Treaty. The total for Superior is again given at 17,232. So I would remind the court that has nothing to do with capitalization. That has to do with the payments that were warranted up to 1892. He gives a total of those two sums. And he says he understands that all parties have agreed to this. He says the award so made would finally close all matters in the Indian annuity case before the arbitrators. And then in the same letter, if we can move to slide 281, Hogg turns to the future after 1892. And he says, he repeats the point that for the Superior Treaty, there is nothing more to be said or done as to the future after the 31st of December, 1892. And that being for the reason that it was understood by him that there would not be any sufficient net revenues to enable that payment. But explains with the Huron Treaty that there is indeed the provision that has to be made for future.
Thank you. Just,
Yeah.
let's make sure that Justice Hennessy's caught up.
Thank you. I'm good.
Okay.
Okay.
Can we move then to slide 282? And actually, 282 is about interest rates and 283 is about calculations related to those interest rates. I think that we can skip over this math and go instead to, because this is dealt with later. If we could skip
Yes.
over maybe to slide 284.
Yes, I think it is kind of summarized in 284. This is Hogg's communication with Irving on the 25th of May, 1899. And Hogg notes that the capitalization question was separate from the issue of arbitration. He said, my understanding of the arbitration is that on the 31st of December, 1892, the Canada account having been made up at the rate of 5% would be closed finally and forever. And any balance which might be shown in that account would be carried into the separate accounts of the provinces. These latter accounts would also be made up at the rates and in the manner specified in the award of August 31st, 1894, and finally closed.
And I think that's a
sorry.
typo there.
Sorry. In terms of the date or,
Well, because if they were made up in 1894, but finally closed in 1892.
I'm not sure. I think that I could look back here.
Actually, the document itself does say 1894.
Yeah,
So
I
if there was a
think,
typo, it's in the document.
yeah,
In any event, I'm not sure
okay.
that's a relevant point. I'm sorry to stop you
perhaps
with
not. And essentially he says, we're now dealing with the matter outside the arbitration altogether.
Capitalization.
Correct.
Okay.
Yes. And he says, yeah, the capitalization of these increased annuities is a matter entirely outside of the principles in the arbitration. He's suggesting here the interest rate of 3%. I think I've alluded to that already. But yeah, I think the takeaway point here is that the annuity for future capitalization was outside the scope of the arbitration.
Can I just ask in the
Yeah.
second line of this quote,
Yeah.
the Canada account? What Canada is that?
I understand that to be the province of Canada. Gosh, you know what,
Thank you for asking that question. In fact, I had a note here as well that I had skipped over.
It just
Yeah.
seems to me that there's reference throughout. In fact, the next slide references to the Dominion when they're talking about the
yes, you're
country.
right, of course.
And so what they're saying here is that the old province of Canada accounts are closed now. We have these provinces, we have the Dominion. Okay.
Yeah, province of Canada account, of course. Yes, that's right.
So I think at slide 285, I think we can skip over because you're just indicating here that internal federal government correspondence indicates the same understanding.
Yes, that's my point in
Okay.
285. Yes, that,
But if we do carry on to then slide 286, that same internal Dominion correspondence from Hogg to Fielding, maybe you could explain this for us on 286.
um,
And take your time because I know I'm rushing you through.
okay, that's, fine. Yeah, this is again, an internal correspondence Hogg to Fielding, the Minister of Finance, the Federal Minister of Finance, on the 28th of June, 1899, explaining that Ontario had wished, besides the matter that was being considered by the arbitration proceedings, how much was chargeable to the province of Canada, or the provinces of Ontario and Quebec, if we want to put it that way, that the amount to be charged in future after 1892 should also be determined. He's saying this is Ontario's wish, and that a final and complete closing of this question should be arrived at, so that no question in the future can be raised with respect to the increased annuities payable under these treaties.
And then slide 287.
And this is my own observation about this communication, which is that Hogg at no point alludes to the clause in the treaty that raises the possibility of such further sum over the $4 level that was the subject of the current arbitration process.
As you say in your slide, or of any possibility of increased amounts beyond the $4.
Right, yes, I'm sorry. Yes, of course, any possibility of increased amounts. I think that slide 288 is points that I've already established. I don't think there's, it's just that his Hogg saying that there's going to be no question in the future for the Superior Treaty about their, this is no hope of any amount being available for the purpose of payment of increased annuities under that treaty.
And I wanted to stop
Yeah.
again, just to remind us that in fact, though, the Dominion is paying already $4 per person for the Superior Treaty. Is that
That is
right?
correct, yes.
So what he's really getting at, there's really no hope of being able to, if I can put it colloquially, saddle Ontario and Quebec with it. Is that,
Yes, I
fair?
think that's true. Yeah,
Because all of the work on those statements had been to identify which years there was net revenue sufficient to increase, and only those years were being charged back.
yes,
So that was the operation they were engaged in.
That's right.
yes.
okay, so then actually we can move to 289. And here we come back to that capitalization rate. So you can go through this with us.
Right, yes,
us.
so I'm sorry, do we want to revisit this or not? It just.
I think so, yeah, it's a good summary.
Okay,
where
yeah,
we
so,
landed on that.
yeah, Hogg devoted much of his letter to discussion of the interest rate that should be used for capitalization. Again, because a lower rate would require a larger sum. So he proposed 3%. Quebec's council said that wasn't fair and that 4% should be used. Ontario maintained that it should be 5% and would be unwilling to agree to a capitalization at a lower rate.
And can you give us the spoiler? At the end of the day, what did they end up agreeing to?
I believe it was 4% that they agreed to in the end.
Thank you. I think then the next slide, 290.
Mhm.
You can take us through.
This is, again, Hogg's communication with Fielding on the 28th of June, 1899. And he says the method of arriving at the sum to be paid in the future after 1892 has taken the form of suggestions as to the capitalization of a sum which would be charged against the provinces in the Province of Canada account. and would constitute a capital from which the amount to be paid to the Indians yearly would be devised. So this is, I guess, him just explaining to Fielding the big picture of how that would work, that capitalization would enable that sum to be paid to the Huron annuitants after 1892. And also that the number of annuitants should be fixed at 2,650. And this would be after considering the amount that had already been capitalized for partial payments at the time of Confederation. He says it would require an additional amount of $8,200 yearly, and that amount should be capitalized. And I just mention that because on the next slide, if I may, on 291, his calculations make it clear that he's really only thinking in terms up to a $4 cap, because 2,650 times $4 is 10,600. The sum that had already been capitalized was enough to, at the time of Confederation, was enough to yield $2,400 annually. So an additional 8,200 would be required.
And just as a reminder, I don't know if I'm going to mess things up, but the amount that had already been capitalized, the 2,400, relates back to the Huron Treaty.
Correct.
Because that's really the 600 pounds mentioned in this.
Yes, that's right. And so $2,000 had been capitalized for the Superior Treaty and 2,400, so a total of 4,400 for the Robinson treaties had been capitalized at the time of Confederation. So Hogg is just essentially saying, how much more do we need to capitalize in order to bump up this capitalization account?
In order to yield
In order to,
10,600
correct,
for the purpose of
Yes.
paying $4
per
for
person.
2,650 annuitants.
Yes, that's correct.
So all of these two slides, 290, 291, are with respect to the capitalization of the Huron account, or capitalization of the amount with respect to payment of annuities to the Huron annuitants.
That's correct. Yeah. And so I just mentioned them insofar as they show what what assumption Hogg is working from. And that assumption seems to be that we need only provide for $4 per person.
Okay, I think we're then on slide 292.
Yes, yeah.
And we're still on the same communication from Hogg to the, was it the Minister of Finance?
That's correct.
Fielding? Yeah.
Yes.
So,
Yeah, Hogg wishes to avoid what he calls the tedious proceeding of working out the exact number of annuitants, Huron annuitants. And so because of that, he wants to bring about a compromise of this matter of capitalization by using the question of numbers as leverage in the interest rate negotiation. And so that's what I meant when I said at the beginning that they kind of considered these two questions in tandem. How many annuitants, what interest rate for the capitalization?
then on, sorry. I was going to take you then to slide 293, where I think we can probably summarize that with that spoiler I noted. That they ultimately agreed on.
Yeah, so again, this is Hogg writing to Fielding.
Mhm.
And he says that he's proposing that we first endeavor to have Ontario accept Quebec's proposition, I'm sorry, and have the sum capitalized at 4%. And then if we fail to accomplish this, that we would accept Ontario's proposition to use 5%. Rather than go to the trouble and expense of calculating the exact number. because a number of annuitants, because he believed that Ontario had shown willingness to accept the number of 2,650. And says that if we can't, that if the amount cannot, after a fair effort, be capitalized at 4%, it should be capitalized at 5%, and the whole matter closed up and put an end to. So I guess this is just about that willingness, I suppose, to compromise and negotiate over these questions of numbers and the question of interest rate.
So that takes us to slide 294.
Yes, so this is several weeks later, on the 25th of August, 1899. Fogg wrote to Ontario's Council Irving to say that he was going to prepare a draft of an order in council that would reflect their agreement in the lines suggested by Irving. The $205,000 charged to the Canada account, Province of Canada account, would be taken to extinguish the annual charge of $8,200 for all future payments of increased annuities under the two treaties of 1850.
Now, it's notable here that we've been talking about these numbers in respect of the Huron Treaty, and yet here it's indicated that the intention is to extinguish this charge for all future payments of increased annuities under the two treaties. Is that right?
Yes, that's what he says. Yeah. And I think his understanding is that a capitalization at this amount would permit payments, would permit the Dominion to continue payments at $4. Yeah, I mean, they essentially asking Ontario to, the Province of Canada, I'm sorry, to accept the $205,000 as a negotiated amount that would cover payments to the $4, with the understanding, I think, that even though the Dominion was paying $4 per annuitant to both treaty territory people, that it was only actually warranted by the numbers in the case of the Huron Treaty. And yet the agreement that was reached seems to cover both treaties to the level of $4 per person.
So this seems to be some compromise by the Dominion.
I think that's fair to say.
You have a question, Justice?
Yes, I missed that. I thought the calculations that we've been looking at were all with respect to the Hurons.
They were.
And what I was reading from this is we're going to sign off to say that both treaties are covered, but we haven't added any, we haven't charged back to the province of Canada any amount for the superiors because we know it's not justified. Is that right?
That's
do
correct.
I understand that?
Yes, that's right. And but again, with the caveat that is to the level of $4 per person.
Well, sorry.
Yeah.
If the Dominion is paying the $4 on their own,
Right. Yes.
they're not including payments. They're not including the increase up to $4 in the capitalized amount. That's what I thought I was reading from the prior slide and even seeing this. So the astute bargainers say we're signing off both. We've calculated a capitalized amount
Yes.
for the Huron
Yes.
annuitants because that's properly charged back to the province of Canada.
Yes.
That amount does not include anything for the superior increased annuities.
Yes, that is
Okay.
correct.
Got it.
And just,
Mhm.
of course, I think we've made the point, the superior annuitants are nevertheless being paid up to their full population by the Dominion.
Yes,
Thank you. Even though the Dominion is not seeking now to recoup anything from Ontario or Quebec in respect of that.
yes.
Thank you.
So let me see if I have this right. The numbers for the capitalization calculation. Which will ultimately be charged back to the province of Canada.
Yes,
Do not include any figures to satisfy increased annuities to the superior annuitants.
yes, that's correct.
Got it. Thank you.
Okay, I think then we could move to slide 295, which I think is an important point. So why don't you take us through that?
Okay, and again, I think because it's important, and that's in fact the last slide in this section, I'll read that if I may. Hogg is writing to Irving. This is the same date as the previous communication. It's part of that letter. And saying, I do not understand that if an agreement is reached between the three governments with reference to the capitalization of the future increased annuities under these treaties, it will be necessary to embody in any award of the arbitrators the result of such an agreement. The arbitrators, of course, must deal with the question of the payments made by the Dominion in respect of the increased annuities to the end of 1892, and their findings up to that date will be embodied in an award. And the future after 1892 will, I understand, be finally and forever concluded by an agreement arrived at by orders in council of the three governments. And I suppose it would take the form of an order in council by the Dominion, and the terms of that order accepted by orders in council on behalf of the governments of the two provinces. So what I understand this to mean is that Hogg is acknowledging to Irving that the arbitration award need not address the question of future capitalization, because that wasn't within what the arbitrators were asked to do, and that rather the authority, if you like, for capitalizing payments after 1892 and our agreement as to what the finality of that capitalization would be reflected instead in orders in council. In the event, in fact, I think the award did refer to the capitalization question, but Hogg is saying that it really is the orders in council and not the arbitration that gives authority to that capitalization sum.
So we're now then able to move to another section, which is to look at those parallel orders in council. And I think we can do this fairly quickly, because although there were three orders in council, they were essentially identical. Is that right?
Yes, that is right. Yeah.
So maybe if we could just go through Canada's order in council, which starts at slide 297. And I'm thinking that it takes us to 305. So maybe if we can try to get through that before the morning break, does that, people ready to go on for another? Okay.
I wonder,
We'll give it a try,
I'm
yeah, but please let us know if you
I'm
need the break.
concerned, Ms. Evans, that from the point of view of the recorder, there is quite a lot of material that I think, because the language in the order in council is important in terms of understanding what it embraces. I did kind of imagine that it would be important to read part of it aloud. I'm just concerned that might,
Yeah, I think
Um,
that's fine.
is it-
If you're
yeah,
going to be reading it
okay.
aloud, in fact, the reporter has it right in front of her then. So
Okay.
let's just give it a
Okay.
try and
all right,
see how it goes. So we're starting at slide 297,
that's
and you're
correct.
going to read for us from the Canada's Order in Council,
Yes, so.
which incidentally is in the compendium at tab 28.
Yes. So that was approved on the 8th of December, 1899. Order in Council 2559.
But you don't, but you started by saying there are 3 identical orders in council.
That's right. And
Each
so
of these paragraphs is identical,
I think the
or the
term,
import is identical.
I think the import is identical is a better way to understand. The language is virtually identical. I don't think there are any differences in substance. My summation of it was that they appear to be identical. And I read them closely, and that was my belief that they were identical in import and essentially identical in language. The essential terms were the same.
Then why don't we go through one, then you point out if there are any differences in the other.
so we'll go through the one.
Okay, I
And you
understand.
in
Yeah,
fact do also go through Ontario and Quebec. So we'll do all of them. That'll be fine.
Okay.
But let's just start with Canada.
okay. Yes, so in summarizing the basic facts of the Robinson Treaty Agreement, Canada's Order in Council said that under the said treaties, the said Indians ceded certain lands to the government of the province of Canada in consideration of a cash payment and the further payment of fixed annuities of $2,000 per annum in respect of the Superior Indians and $2,400 per annum in respect of the Huron Indians, which sums were to be increased under certain circumstances and conditions set out in the treaties to an amount not to exceed $4 for each Indian. I've noted here that it did not elaborate that the treaties contained a clause adding or such further sum as Her Majesty may be graciously pleased to order, unquote, which seemed to me an important oversight in these orders in council.
Slide
I'm sorry,
298.
298, yes. The exact wording in passages of this order in council is, I believe, significant. It says that at Confederation, in the settlement of the debts and liabilities of the province of Canada under the BNA Act, the amount of the said fixed annuities, namely $4,400, was capitalized at the sum of $88,000, which sum was charged in the province of Canada account and formed part of the debt of the said province of Canada. The order in council elaborated that this capitalized sum was sufficient to enable the Dominions to pay the Indians the quote amount of the fixed annuities, which fixed annuities have always been paid, and no question has arisen in this arbitration as to the said fixed annuities. It said that in response to representations by the First Nations to the Dominion in 1874, that the treaty lands had produced enough revenue to quote justify the payment of the increased annuities up to the amount of $4 per Indian. Thereafter, the Dominion has paid to each of the said Indians the sum of $4.
Then slide 299.
That's correct, yeah. The phrasing in the section that follows suggests that the Dominion government's order in council was intended to refer only to the said annuities. And I take that to mean the annuities up to the amount of $4 per claimant. Nowhere does the order in council refer to a larger amount than that. And I can confidently say that that's true of all 3 orders in council that we're discussing. Can we go to slide 300?
Yes, and I think
Or-
that slide 300
yeah.
deals with the non-capitalized amount.
Mhm.
Because we see
Yeah.
there again.
Yep.
The superior treaty amount being the sum of the 17,232,
Uh-huh.
which reflects those 6 years before 1892.
Mhm.
So slides, 300 and 301 deal with that non-capitalized amount. And I think for
Yes.
our purposes here, we're really interested in the capitalized amount.
Well, I would suggest that just one important thing, that, one very brief phrase that I would say is important in slide 300, and I address this in slide 301. So I can't predict whether it's important to this larger case or not, but my observation is it says the said increased annuities, and my point being that I take to mean increased to $4 per person. And again, I don't know if that's relevant information or not, but I thought it bears
Well, it's-
mentioning.
It's past tense, right? Increased annuities. And we know
Yes.
they have paid $4.
Yes. Yes, yes.
So can we move to slide 302?
Yes.
Because here here the order in council is dealing with the
Yeah.
capitalization, and it might be helpful if you were to read that. then.
Yes, this passage, I guess I think should be read. That since the 31st day of December 1892, the Dominion government has continued to pay the Indians under the said treaties, the said increased annuities, and the Indians will be entitled in future to receive and be paid such increased annuities, and suggestions have been made by the several governments interested that instead of the governments of the province of Ontario and Quebec as representing the late province of Canada, paying to the Dominion an annual sum to satisfy the said increased annuities, it would be well that the said government of the provinces of Ontario and Quebec should be relieved from the payment of an annual sum to the Dominion to satisfy in the future, after the 31st of December 1892, the increased annuities payable to the Indians under the terms of said treaties, and that in order to carry these suggestions out, I'm not sure if that's my typo or not, it says and annual sum, it should be an annual sum, should be capitalized, sufficient to satisfy the amounts payable by the provinces of Ontario and Quebec in respect of the said annuities, and the capitalized sum charged to the province of Canada account. Should we move to the next slide?
You're just, so in
Yeah,
this
I'm sorry.
slide.
Yeah.
It says the OIC is providing a rationalization of the capitalization.
Yes, I think so, that rather than having, requiring the provinces of Quebec and Ontario to annually supply an amount, it would be dealt with in capitalization.
And then slide 303. You're continuing to quote from the order in council here.
Yes, I am. That negotiations to that end have taken place between the said governments, and the sum of $8,200 has been agreed upon as representing the amount which the provinces of Ontario and Quebec would be required to pay to the Dominion annually towards the payment of the said increased annuities, which sum capitalized at the rate of 4% as agreed upon would produce the sum of $205,000. So there we have the agreement as to the interest rate.
Now,
4%.
this causes me some confusion. This goes back to something we said earlier.
Mhm.
Does the $8,200 annually include paying superior annuitants $4?
It would not allow for that amount. It would only allow the Dominion to be deriving from the provinces enough that was understood to satisfy the payment of the Huron.
That's exactly what I,
Yeah, yeah.
so I had earlier understood. So slide 303, when the order in council says that the sum of $8,200 was agreed as representing the amount the provinces would be required to pay annually toward the payment of the increased annuities. They're still talking about, as I understand it, the amount of the justified increased annuities.
Yes, I think that if I,
Is that a way to put it? The word they used earlier was if there were revenues in excess of expenditures, then the increase was justified. They're saying after 1894, there were no increases
74.
justified. 74, there were no increases justified. Okay,
But remember here, we're only talking about payments for the future.
yes.
Okay, and also, it's a very interesting question. Does the 8,200 include the Hurons and the Superiors? Professor Messamore, you've told us that it was calculated based on only the Huron obligation,
that's right.
but the Dominion was effectively releasing
Well, that might be
Ontario.
leading, but go ahead.
Yeah, I'm just trying to be helpful, like.
No,
to- it-
but
to-
I
Okay.
got what I
Oh,
needed.
Sure,
That
okay.
there was no, that the Dominion was taking care of themselves with respect to anticipated continuation of increased annuities, and was their understanding that those increases could be justified. So therefore, they wanted the province of the provinces
Mhm.
to be obliged to take care of those. Whereas whatever they were doing with the Superiors, they weren't charging that to Ontario. But as when I commented earlier from the correspondence, the bargainer said this takes care of both treaties, and the OIC refers to both treaties being taken care of by
Yes.
this capitalization.
Yes, to the level of $4, because we're talking about future
Yes.
payments in this context. Yeah.
Thank you very much, Justice Hennessy. And I'm sorry that I was leading the witness. I guess I'm trying to forestall cross-examination on this point. I don't want it to be seeming as though we're misrepresenting anything, but it's clear that you do understand it.
You're not going to forestall crossing.
Okay, yeah. Yes, wishful thinking, wishful thinking. So actually, I think we're really ready, just about to break, because I think we can skip 304, its calculations, which I don't think we need to go through in any detail here. And perhaps then you could take us to slide 305.
Okay. And so continuing with the order in council. Yeah, so we've got calculations. That the said capitalized sum of $205,000 above mentioned be charged to the said Province of Canada account as of the 31st day of December 1892, and be taken to extinguish forever thereafter the annual charge of $8,200 for, and in respect of the annual claims of the Dominion on behalf of the said Indians for increased annuities under the said treaties, and that the province of Ontario and Quebec, as representing the late province of Canada, be from and after the 31st day of December 1892, relieved from all liability and further payment in respect of the said increased annuities, which may be payable under the said Huron and Superior treaties. So I think that partly answers the question Your Honor asked about both treaties.
Thank you.
And then very briefly, you go through Ontario's order in council and Quebec's order in council, and as Justice Hennessy suggested, perhaps you could just advise if there are any significant differences.
Not to my recollection. I read them with this particular question in view about what agreements they included, and I'm not aware of any difference.
In fact, you say you address that at the bottom of slide 306. for
Yes, I
example.
say it was essentially the same language, the Ontario Order in Council as the Dominion Order in Council with minor variations. And then I say on slide 308, I say that the Order in Council was approved in Quebec with essentially the same terms. So I do quote briefly from the Ontario Order in Council, if that's relevant, but I think that when I look at that, yeah, no, to me, the language seems to be the same. They refer to first to increased annuities under the said treaties. The said increased annuities, and that it refers to the Huron and Superior treaties. And I think those are the salient points in each instance.
Well, it would be a good time, I think, for a break. We don't have that much more to do, and we have planned to skip over some of what is coming. So I think we could probably wrap up within half an hour.
After the break?
Yeah.
Thank you. Okay. Let's take 15. Thank you.
All right. Or recess for 15 minutes. Ms. Gomez, you may be seated. Professor Messamore, we left off at slide 309,
Yes.
where we're now into the 15th award, and we've just got, I think, 5 slides to deal with on that, starting at slide 310.
Yes.
So can you explain the 15th award for us, please?
Yeah, Award 15, as I think I've said, was based upon the agreement negotiated between the Dominion, Ontario, and Quebec. And among other claims submitted to the arbitrators were those concerning the Robinson treaties.
This is just really an introduction.
Yes.
I think section 311 is the
Yeah, so
relevant commentary.
yeah, the payment of certain arrears of increased annuities and for money paid by the Dominion government after 1874. So yes, if we could go to slide 311. My point was that the award 15 didn't reflect a position newly arrived at, but by the arbitrators, but was rather a statement of the agreement that had been reached as a result of negotiations and that had been encapsulated in separate orders in council.
I think then we can move to slide 312.
312, yes. So Award 15 said that with respect to the Lake Superior Treaty, that there be entered and charged in the province of Canada account against the said provinces as represented by the provinces of Ontario and Quebec, the sum of $17,232, of which the sum of $3,068 is to be entered and charged on December 31st, 1874, and the balance or sum of $14,164 of the date of the 31st of December, 1892.
And then slide 313 gives the comparable calculation for the Lake Huron Treaty, which is lengthier, of course, because
Right.
there were 14 years there. And I think we can skip over that detail.
Yes, I think so.
So we're now on slide 314.
Yes, and that refers to the capitalization. It says, with respect to the said treaties, that there be entered and charged in the province of Canada an account against the said province as represented by the provinces of Ontario and Quebec. And as of the 31st of December, 1892, the sum of $205,000 in extinguishment forever thereafter of any claim by the Dominion of Canada on behalf of the said Indians for increased annuities under the said treaty. Now I have in the next slide in 315 remarked on the potential ambiguity in the last clause, which said extinguishment forever of any claim by Canada, Dominion of Canada, on behalf of the said Indians for increased annuities. Word 15 reflects the language of the orders in council passed in Canada, Ontario, and Quebec. But the orders in council, I would suggest, are more specific in the sense that they use the phrase the said increased annuities, which would, I think, be taken to mean the increased annuities that have been the subject of discussion, that is, increased payments to $4 per capita. One might say that saying for increased annuities without saying for said increased annuities might be potentially ambiguous. I don't know if that's something that would be a concern or not, but I think that's why I thought it was important to note 2 points. One being that the award reflected a negotiated agreement that had already been reached and wasn't the decision of the arbitrators per se. Let's see, that was the one thing that was important to say, and that the language of that discussion concerned payments to $4 per capita. So I think if we can go to slide 316. I also have observed that with respect to this potentially ambiguous phrasing in Award 15, it's important to think about the implications of what an alternative reading might be. And I suggest that based on what I've observed about the process of the debt allowances, the confederation agreements and everything else, that it would have been most improbable that the Dominion government would assume a sort of open-ended liability with respect to an obligation that had been hitherto borne by one of the provinces. And this is based on the fact that historically, great care was taken to ensure equitable financial arrangements in confederation. So I describe it as unlikely that the Dominion would at a stroke overturn that tradition and make a transaction that could potentially increase very substantially the amount of debt assumed, in effect unilaterally increasing the debt allowance for a single province. And I think it's even more unlikely that if they had done so, that they would have done so in such a way shrouded in potential ambiguity. That would represent a major change in the financial arrangements of confederation. And had it been understood in that way, it would have been immediately seized upon by the other provinces as the occasion for general increases to the debt allowance.
Can I see if I get that?
Yes. Yeah, I don't know if the distinction is important, Your Honor, but I just note that Award 15 uses the language in extinguishment forever of any claim by the Dominion of Canada on behalf of the said annuities, or sorry, behalf of the said Indians for increased annuities under the said treaty. And my point was that the actual orders in council upon which this award was based used the phrase said increased annuities. Now, I'm a lawyer. I don't know if that matters, but my point is
You're
that,
not a lawyer.
I'm sorry, no, that's why I said I'm
Yeah.
not a lawyer. Yeah, that I think it's important to recognize that what's under discussion is annuities to the amount of $4 per person, and that there isn't any, in any of the discussion that culminated in this award, any consideration of amounts beyond that ultimately there might be an obligation to pay something beyond $4 per person.
Okay.
Yeah.
Now, the next part of the presentation
Ms.
deals with,
Barclay, huh?
Oh, I'm sorry.
I maybe rose a little bit too quickly. I don't know what Ms. Evans, my friend, is going to say about the next portion of it. We do have a concern about it. The remaining slides. Can you? Well, so what I was going to say is this, the remaining slides from slide 317 to slide 324 of Professor Messamore's demonstrative, this is entirely new material, we would say. She does not in her report deal with the 16th award, nor does she deal with the set off. These are things that Gwyneth Jones in her report dealt with. And that report was served a year and a half ago. There's been no reply to it. Now, technically, my friend would require leave to include this, we would suggest. I don't have an issue with leave being granted, Your Honor, so long as I just want to flag that it's new and that Ms. Jones, when she has an opportunity to testify, can respond on what's in these slides and anything Professor Messamore might say on the stand, because she's not seen this before. We've not seen any comments that Professor Messamore, excuse me, has made about the remainder of this deck. Thank you.
I'm never sure what flagging means.
I beg your pardon?
I'm never sure what flagging means. All right, you're not asking for any direction or order at this time.
Well, I would suggest to you, as I noted, that because this is new and it's not the subject of her original report, nor did she
Yes.
take an opportunity to make a reply to Ms. Jones,
Yes.
that this is new, we haven't seen it.
I got what you said, but my question was, if I understand, you're not asking for any direction or order at this time.
If leave is going to be granted, so that she be permitted to speak about this and to provide testimony about it, and I assume that my friend is going to be asking at the end of her testimony that the entire demonstrative be marked as a lettered exhibit.
Mhm.
I'm just flagging that it's new, and I'd like to make sure that Ms. Jones has an opportunity to comment on it.
Got it.
Thank you.
I'm not making any orders at this time. I understand.
what I was going to say, Your Honor, is that this next section deals with the 16th award,
Mhm.
which Dr. Messamore didn't deal with in her report.
Got it.
And this was prepared in response to Gwyneth Jones's report. But we're going to skip over that because I'm going to deal with that in cross-examination of Gwyneth Jones. And I'm happy to rip these pages out of the slide deck if that's what my friends would like me to do. That's what I was going to
Well,
submit.
that's
fact, I
if,
think-
that's if and when you want to, as I've been saying, promote this exhibit to a numbered exhibit.
Okay,
But if and when you do, then that's what. you can do.
sure. But that's in fact what I was going to say. I was going to say, let's just skip over this because we're short on time and I can deal with it by cross-examining Gwyneth Jones. And so I knew that that would cause concern if we're not going to deal with it.
Mhm.
That it clearly acknowledges that Professor Messamore is quoting from Gwyneth Jones, like the material in Gwyneth Jones's report, but I'm
Sounds like
happy
it-
to rip it out.
Sounds like it's a non-issue.
I think so too.
Okay.
And I think that, but for slide 200 or 324, we're done with the slide deck. Can we just go then to slide 324?
Yes, slide 324 is simply an observation that the payment of arrears were made to the Government of Canada accounts of the Robinson Treaty Ojibwe during the fiscal year ended the 30th of June, 1903. The payments appear in the report of the Auditor General for that year. payments to the annuitants themselves evidently followed in due course in late 1903, according to some records and correspondence with agents in various locations. I think in the last section, I should have said payments of arrears to the annuitants themselves. So that's that was just simply an observation of wrapping up of the transactions.
Thank you. So that deals with the slide deck. And in your actual report, at the end of your report, you provide a bit of a summary of your opinions. And
Yes.
I would ask that you just, at the end of your examination in chief, summarize for us what you feel are the most important points that you'd like to make sure have been communicated to the court in this
Okay.
presentation. I'm just going to leave it to you to let us know what you think are the
Okay.
points you want to comment on.
Yeah, so I stated the opinion I was asked to render at the beginning of this process, but I'll just recap here that in considering the history, it seems clear to me that the increased annuity amounts due under the Robinson treaties in respect of, or I should say, increased annuity amounts due in respect of the pre-Confederation era should logically be treated as part of the province of Canada's debt. And
Can I just ask where you're reading from?
I'm sorry, this is the section 250 or page 254 of my report.
Your
I'm just
report.
looking at, yeah, I'm
Which
trying to
was marked
sort of
as
just pull
exhibits.
out a couple of points from
Thank
that
you.
section of the report, the opinion section.
Okay,
This was marked as exhibit 78. It's the report. And you're looking at 254. I just want to bring that up if people want to follow along.
Yeah, I'm just starting there, yeah. And so my intention was not to read this, of course, but just to pull out the few points to tie up, I guess, what I've said to make sure my, the ideas that have gone into forming my opinion are clear. And because of that, it might seem logical that any increased annuity payments for the Robinson treaties for the post-Confederation period should be treated in the same way as the original amounts, capitalized and treated as part of the debt for the province of Canada. But I believe that a different conclusions warranted based on the consideration of the entire historical context. I've said before that I lack legal expertise to offer any opinion about whether the obligation to pay increased annuities based on the amount of revenue derived from the territory is a trust under section 109 or a debt under sections 111, 112, and 142. But I have also observed that according to the principles that inform the division of debts between Ontario and Quebec, it would be difficult to find any rationale for requiring Quebec or the Dominion government to bear a share of these obligations. I believe that the obligation to pay any increased annuities under the treaty based on the amount of revenue derived from the treaty territory in the post-Confederation period properly lies with Ontario. And I'll just try to explain, again, recap why I came to that conclusion. The first point being that debt allowances allowed to the provinces at Confederation were limited and specific, that they were only ever increased for all provinces together and never for a single province alone, that the debt accounts maintained by the Dominion government for the provinces were frequently adjusted as new obligations dating from an earlier period came to light. So there would be adjustments to those debt accounts. The debt account, of course, of the province of Canada, I'll remind the court, was shared on an approximate 53-47 basis, 53% being allocated to Ontario. And it's this kind of observation that informs my view that it would be improbable that the Dominion government would agree to a transaction that would have the effect of very substantially increasing the debt allowance of any one province. Any additional debt assumed by the Dominion carried with it the obligation on the part of the province to be liable for that additional sum and to pay interest on it. So that was my point about the ambiguity in the in Award 15. I've already observed in my testimony that I think it's instructive to think about the 1858 original plan for Confederation that Alexander Galt articulated. And I think it's instructive because Alexander Galt was the person whose ideas most informed the financial arrangements. And I noted when I discussed this that in 1858, his original thinking was that public lands would be under federal control, with the provinces receiving the net proceeds of that. I also thought about a question that Your Honor raised about why the decision was taken at the time of Confederation to capitalize the future annuities and to add them to the debt of the province of Canada. And I think a bit about what the alternatives might have been to doing that. I think with most of the annuities, the so-called old annuities or the civil list annuities, the decision to treat them as debt and to capitalize them made sense because it was a clear quantifiable amount, the debt obligation. It was understood that it wasn't going to change. The Robinson treaties, of course, are different insofar as the obligation to pay the treaty annuitants might ultimately grow, and indeed did. So in that sense, it made less sense to treat the Robinson treaties in the same way. But I said that at the time of the Section 142 arbitration, there was no indication that the arbitrators realized that, or contemplated at least, that these treaties were distinct in that respect, in that they tied future payment to a share of revenues in some way. Reverting to the question of why future payment for treaty annuities was capitalized and treated as debt is also, I think, perhaps seen as a way to secure those payments, to assure that funds were laid aside to pay the annuities and that the obligation to continue to pay them was understood by the parties. And I think this isn't necessarily a groundless fear. I think when we look at some of the language used, for example, by Oliver Mowat in Ontario, the language used by Treasurer Ross in Ontario, questions about, well, are we really obligated to continue to pay descendants? And is this person really a real Indian entitled to payment? There's some grounds, I suppose, to suggest that, you know, the expression is you don't leave the fox in charge of the hen house. I don't know if that's applicable here.
It's
but
very
In fact,
legal.
we've,
I'm sorry?
It's a very legal observation.
Yeah.
it's been observed in
Oh,
that
has it?
case
Okay, okay.
earlier.
Yeah, so just simply that this isn't to suggest that Ontario is in any sense untrustworthy, only that the party who is obligated to pay would not necessarily be the most disinterested observer of what that obligation might be. And I think there's also some relevant antecedents when we think about the pre-Confederation era. that we see the imperial government at times reminding Canada about their obligations and making sure that those have been provided for in capitalized annuities. So, for example, let me just look at the report here. Yeah, I have, for example, on January 30th, 1844, Lord Stanley, who was then Secretary of State for the Colonies, recommending that, quote, measures should be taken for securing to the Indians their annuities, provision for which had been overlooked in legislation for the Act of Union in 1840. And Amelia Irving, in fact, for Ontario, said that the omission of annuities had become a subject of remonstrance by the imperial government to Canada. Yeah, I move on to addressing the dilemma created by the 1870 arbitration. And by that, I mean that the decision to treat all the annuities, including the Robinson treaties, as debt under section 111 and 112, essentially forced the Dominion provincial arbitrators into a position that introduced an apparent inconsistency. The section 142 arbitration, of course, thought about the debt in terms of origin for it, who derived benefit, whether Ontario or Quebec derived benefit from that debt. And that was, of course, the calculation that Ontario was responsible for 53% and Quebec for approximately 47%. Their thinking, or I should say their actions really demonstrate the thinking that they saw the Robinson treaties as quantifiable and
Who's
something.
they here?
I'm sorry, I'm talking about the section 142 arbitrators.
I thought something.
Yeah, that they treated them as debt, and moreover that they believed that even though it was understood that Ontario alone would derive the benefits from that territory in future, the Robinson Treaty territory, they seized upon the convenient offsetting obligation of an almost exactly equivalent annuity obligation in Lower Canada, that 1851 provision that was for £1,000 or roughly $4,000 annually, an amount that was capitalized at 80,000. So the thinking was, I believe that, or at least the evidence suggests that these two amounts could both be treated as debt capitalized for the future, not appreciating that the amount due to the Robinson Treaty annuitants could change. And of course, the general view seemed to be that the treaty claimants' request for augmented annuities were only widely recognized after 1873. Yeah, so had that actually been thought about fully at the time of the section 142 arbitration, had it been appreciated how that these Robinson Treaty obligations could not in fact be positively quantified and capitalized, that would have made it very difficult to arrive at a satisfactory capitalization sum, because it was an unknown future obligation. It couldn't really be fully quantified. Yeah, I think I can, yeah, skip ahead now to the arbitration of the Dominion provincial arbitrators.
Could I just
I'm
ask you
sorry,
one
yeah.
question?
Yes, of course.
When you say that the general view that the claimant's request for augmented annuities were only widely recognized after 1873, what does recognized mean there for you? That the government was recognizing, accepting that there was a claim, or that they were noticing that there was a claim, or that they were noticing that there was an obligation to look at increased annuities?
I would say that they noticed that there was a claim after 1873, that petitions were being brought forward and being discussed after 1873. It wasn't, as I think we've observed, the first petitions that were made, but it seemed to be the first time that these petitions for increased annuities were being widely recognized by indeed both the federal government and by Ontario. So thinking then about the arbitrations of the 1890s, the Dominion provincial arbitrations, they had to work within the confines of what had already been done in Section 142. It seemed to be widely accepted that it would be impossible to go back and reopen the 1870 arbitration decision about debt under Section 142. In the intervening years, we know that there was general acceptance by Ontario and Quebec that the Robinson Treaty claimants were entitled to larger payments, that we have Mowat acknowledging that for Ontario in October 1874. We have the Liberal Minister of Justice, Edward Blake, agreeing in 1875 that surely they're entitled to payment up to the $4 per head. Minister of Interior concurring in that same position. And so this was one of the questions considered by the Dominion provincial arbitrators in that process that commenced in 1893, who was responsible for that increased amount. They ruled, as we'll recall, that for the period up to 1867, it would be a province of Canada obligation because both Ontario, Quebec together as the province of Canada enjoyed any revenue at that time. But at the, with respect to the post-Confederation payments, the arbitrators decided that the answer was to treat the obligation as a Section 109 trust rather than a debt of the province of Canada together. And they believed that the burden fell upon the province of Ontario. And the way to reflect that was to consider the post-Confederation treaty augmentation a Section 109 trust. And so this, as I said, introduces an inconsistency because it wasn't how the annuities were dealt with at the time of Confederation. It would mean, as I think we've observed, that part of the annuities were being paid under a Section 111 debt, and part of them, if it borne out, if it had been done according to their ruling, part of it would have been paid as a Section 109 trust. But it seemed to be the only way that they could say this responsibility lies with Ontario and not with Ontario and Quebec jointly. That only way seemed to be to describe that obligation as a trust. They knew they couldn't go back and reopen the 1870 Section 142 arbitration. We know, of course, that the Supreme Court and the JCPC overturned that ruling on appeal. They privileged consistency because the 1870 award had been, considered that annuity obligation a section 111 debt, sorry. They believed that the same should be true for the post-Confederation obligations. Because of that, I believe that the post-Confederation annuity amounts should be chargeable to Ontario. To have the federal government absorb the cost would be in effect to make an adjustment to the debt allowance for a single province with no compensating adjustment for others. To have it charged to the province of Canada would be in effect to violate, would be to share it between Ontario and Quebec jointly. And that would be, I think, a violation of the principles that, however imperfectly, guided the Section 142 arbitration. They tried to use the local benefit principle to decide on responsibilities. It wasn't a perfect process, but that was the essential process. And I think if there had been a very substantial sum that was understood to be due with respect to a territory in Ontario in future, had they known that, which of course they couldn't have known at the time of the 1870 arbitration, that probably would have affected the 53-47 ratio, or there would have had to have been some other arrangement. And I say they couldn't have known because they couldn't have known what amount would ultimately be due. And I just think that a full appreciation of this context is important when considering the meaning of Award 15. Award 15 seems to strike a note of finality. You know, it refers to extinguishment forever of any claim by the Dominion of Canada on behalf of the said Indians for increased annuities under the said treaties. I've already said that the negotiations leading to Award 15 did not include any Indigenous representatives. They were not part of those negotiations. But my point is also that this discussion leading to Award 15 was only ever in terms of payments up to $4, that there was no consideration of any release for any larger sum. Well, I should say there was just no consideration of any larger sum, period. That would be a better way to put it. And I think that is all that I wanted to say in summing up the points in my report.
Thank you, Professor Messamore. I found that summary very helpful. That concludes the examination in chief of Professor Messamore. And with respect to the question of the marking of the slide deck, I'm actually quite content to leave it as a numbered exhibit because it really just does summarize.
Leave it as a lettered
As
exhibit?
a lettered exhibit, I'm sorry. Because it really does just summarize the report. And I think that the report really is the more detailed source and really should be read and understood and quoted from in its entirety. So while the slide deck's been very helpful to guide the testimony, I think I'm quite content to have it remain a lettered exhibit.
Okay, so that's helpful if, and I'm just double checking, if there's very good references throughout the slide deck to the report. Or
you know, I confess that I'm not sure everybody is on the same page with respect to the difference between a lettered report and a numbered report.
oh. Well, a numbered exhibit is evidence in the trial. The lettered exhibit, from my understanding, is something that came into the court for the assistance of the court during the evidence. But the evidence is what comes out of the witness's mouth or what is in a numbered exhibit.
And I think the numbered exhibit should then be the report itself.
Well, it is.
Yes.
It is an exhibit. But
I know that, I
I'm
think it's the case.
looking at the pages and I see that there is a report page reference. It appears to me on every slide.
Except and somewhere Professor Messamore is just giving opinions, which are then, of course, on the transcript.
I'm content if that's how you'd like.
Well, I just really do feel like, given that it is a summary of the report, I think that I would rather have the parties, for example, in their closing submissions, reference the report.
Well, you can tell them.
Well, now they know that this isn't actually an exhibit. And I don't know.
Well,
whether or
it's not, it's an exhibit. It's a lettered exhibit. It is not the evidence at trial. Unless someone disagrees with how I've identified those or characterized those. That's how I've always understood it. Mr. Schachter's going to help me.
Yeah, I mean, I just have to say, I see this as more of an issue of what works for the court and how, when you're sitting in that room alone, as you told us, what assists the court in doing its job. And I personally, all the other slide decks have been numbered exhibits, not just lettered exhibits, and I'd be okay with that. I know there's the problem of the last 3 or 4 pages, but other than that, I see it as an issue for what's easier for the court, not what's easier for counsel.
Well, that's why I was looking at page references, because it is easier for me to work with bullet points and pages with a lot of white space when I am trying to organize materials. So I would like to be able to work with the slide decks. And I have annotated them throughout the evidence where I'm not annotating the reports.
Okay.
So it is very useful for me to be able to rely on the slide decks as evidence, and promoting it to a numbered exhibit probably helps. And if the pages that are of concern to Ontario and have not been a subject of oral evidence should be removed, that's easily done. And that actually helps me.
All right. Of course, we'll do what helps the court. So, I should say that I'm quite happy then to identify, and if you want, physically remove the slides that deal with Award 16, but I don't want that to be taken as a concession by me that Professor Messamore is not qualified to speak on this. I've chosen not to take her through it orally because we wanted to speed through.
I'm not making judgments about what she's qualified to speak on if it's not in evidence.
That's right.
So it's not if it's not in evidence, either in her report or, I mean, frankly, you might have decided, I might have been quite open to having that evidence called orally if it's in response to another witness.
And that's why it's included in here. That was what the intention was. In fact,
To call it as evidence.
to call it as evidence, it's appropriate to respond to another expert's report without having to enter a reply.
Right.
But I simply made the choice to speed through. I don't think it's important enough that I
Okay.
can't deal with it with Ms.
So you're
Jones.
content to remove pages starting at 317?
2, 3, 22.
322. So that is 317, 18, 19, 20, 21, and 22.
That's right.
All right, I'm gonna ask the registrar to remove those pages from this. And then you'll ask to make this an exhibit. I'm not sure. Any problem with that, Ms. Barker?
That's fine, Your Honor. Thank you.
That's a good solution for you?
Thank you.
Okay. 81? Thank you.
Perhaps I might just add, at the risk of
Mr.
complicating this
Grant.
a little bit further,
All right.
might it make the most sense to keep the entire slide deck with the pages that are being removed
Mhm.
as the lettered exhibit, and then make the version without those pages the numbered exhibit for ease of record or anyone following along with the transcript in the future, understanding what's being referred to when we were referring to these pages that are being removed.
If one was following the transcript, there would be no references to these pages.
There was the discussion on the record about Ms. Barkley's discussion on the record and the discussion about removing them.
Right, there was a discussion on the record about removing references to Award 16.
Right.
Unless you're telling me I have to do that.
I don't necessarily feel strongly one way or the other. I just thought it was a point that I would raise for the consideration. of
All
the
right,
board.
well, let's say for the record then that these pages 317, 322 are not in my mind. I did not read the slide deck after it was handed up on the first day of evidence. It's not in my hands prior to the witness coming onto the stand. And there has been no evidence with respect to it. It has been identified solely by counsel in their submissions as whether it's properly before the court or not, and the decision by Canada is to take it away from the court. That's my understanding. So I'm content to use this document. I'm sensitive to what you say, Mr. Bass, but I think we can handle it this way. I'm content to make Exhibit X into Exhibit 81 with the pages which have not been the subject of evidence being pages 317 to 322 inclusive, removed by the registrar. Sound good? Thank you. Thank you.
The amount of time that we spent discussing that, I might have just spent in having the witness go through it. In any event. That does conclude my examination in chief of Dr. Messamore.
All right, thank you very much. Who's next? Chelsea?
Your Honor, could we go off the record just for a moment? Could we go off the record just for a moment?
Yes.
Thank you for the indulgence, Your Honor. Good morning, Professor Messamore.
Morning.
I introduced myself to you last week. For the record, of course, my name is Tamara Barkley, and I'm one of the counsel of the Ontario team. I'm going to be using your slide deck and your report and taking you through some of the testimony that you've been providing for the last couple of days. And I will likely be asking you to clarify some of the points that you've said, okay?
Okay.
To assist with that, Your Honor and Professor, we've prepared a compendium of documents. You won't be surprised to hear. It's been circulated both electronically to the court and to my friends, and hard copies have been passed around, including to Professor Messamore. I believe she has a clean copy in front of her. With that in mind, then, Your Honor, I would ask this to be marked as the next lettered exhibit. I believe that would be Y. Oh, I've missed one. Thank you.
That's why, that's why. Oh, that's right. I warned you we would come to the end of the alphabet.
I remember you saying we needed to save letters. All right. Now, Professor, I don't mean to belabor the point. You've said quite a few times that you're not a lawyer. You said that on Friday as my friend was going through your qualifications. I take it you didn't get a legal education over the weekend.
That is correct.
All right, thank you. And in fact, your post-secondary education and your teaching career, if I understand it from your CV, it's been focused exclusively on the study of history,
That is correct.
Canadian history in particular,
Yes,
and British history as it relates to Canada.
correct.
Thank you. And I saw nothing in your CV that you've taught legal history,
No, I have not.
nor have you taught anything respecting interpretation of legal documents or legal drafting.
That is correct.
So I think you would accept then that questions of the proper interpretation or what might be just in this particular case, that's a matter for the court and Her Honor to determine.
When you say proper interpretation,
The legal interpretation
Oh,
of what a
legal in-
document means.
yes, legal interpretation, certainly. I mean, historians, of course, interpret documents all the
Of course.
time in context, but that's not a legal interpretation.
Of course. And as well, what justice might dictate in a particular situation from a legal perspective, that's also for the court to determine.
From a legal perspective, certainly.
Thank you. So it feels like years ago we were talking about Confederation,
Mhm,
but I'd like to go back in time to that.
Sure.
In fact, I'd like to go back a little bit earlier because of course, I believe your testimony and your report, I don't think it's in dispute. Confederation was a negotiation, is that right?
That is correct.
And it started at least some 10 years before what we think of as Confederation, 1867, right?
Well, perhaps not the negotiation per se, but ideas were being mooted, certainly at least 10 years before.
And you've talked an awful lot about Alexander Galt being one of the driving forces of that.
In terms of arriving at a sort of concrete plan, yes.
And he, in 1858, started making proposals about that plan, isn't that right?
That's correct.
So it's not something, it's fair to say, that happened overnight.
Correct.
Now, one of the things that I recall you saying was that Mr. Galt, should I call him Minister Galt, Mr. Galt? Doesn't matter.
Mr. Galt, yeah.
He was, I believe, the Minister of Finance for the UPC,
Yes, he was.
and he was a representative for Sherbrooke.
Yes.
Okay, so in that speech of 1858, when we progressed through some of the conferences, then ultimately, and I don't have the dates concrete in my mind, but ultimately we get to what you called the Quebec resolutions, right?
I'm sorry, can you repeat the first part of that again?
Yeah, that was a bit unclear. So the Quebec resolutions, I think you said, were meant to go back to the table, such as it were, and to sort out some of the financial aspects and put them down on paper, that what Galt had been talking about for a couple of years now, and other founders as well. Is that right?
Well, I would suggest that we can't know exactly what the Quebec resolutions were meant to capture because we don't have a verbatim transcript of what happened during the Quebec conference. But I think the Quebec conference is understood to be a continuation of the Charlottetown conference a month before. And this entire process was, as you say, a negotiation. Galt took a lead role in many of the financial proposals, but negotiations happened to culminate in the Quebec resolutions.
Yeah, and I'm not trying to catch you out on anything.
Yeah.
I bit of a warm up, I suppose.
Yeah.
I thought I remembered you saying that the Quebec resolutions went back to the table about some of the financial aspects that had been discussed. And they created a document which listed them out for the first time.
I guess I'm not quite clear about what it means to go back to the table. I'm not quite certain about what you mean
Okay.
by that.
And I'm not sure much turns on it, so I'll move on, and if I give it some thought and find it in your transcript,
Okay,
that's fine, but I don't think it's that significant.
okay,
You will agree with me, I think, though, that as early as 1858, Galt was proposing that there be a central, or what we think of now as a federal government.
yes, that's correct.
And he also proposed that that new sort of central government would have power over a number of financial matters.
Yes,
And those included exercising control over trade
yes,
and customs and excise duties.
yes.
I'm
And
just going to ask you, Ms. Barkley, as I have
Slow
asked
down.
others, just count 2 beats between the end of an answer and your new question.
Absolutely.
Thank you.
In 1858, he also proposed, this is Galt, that the central government should have control over Indian matters.
I would have to review the report, see, just to make sure.
I'm at page 42. I believe, of your
42.
report. You talk about what Galt proposed. It might be 42. I have a copy without the table of contents. I have a page that begins at the bottom line. The brief sketch also
Oh.
included the following.
I'm sorry. Yes, it is page 42. Yes, and what it says is it lists the powers. It says in government of unincorporated Indian territories. Is that what you're referring to?
Yes, that's right.
Yes.
And then the Quebec resolutions, those came out of a conference in October 1864, you told us.
Yes.
And then I know that you set these out in your slide deck. We didn't have an opportunity to hear about them in detail, however, so I'd like to go through some of them. So your slide deck has now been marked as Exhibit 81. And I'd like you to turn up, if you would, slide 71. In front of you on the screen as well. So again, I would suggest to you that we see Galt's influence here in that some of these resolutions, they set out and refine some of those proposals he had made in 1858. Isn't that correct?
I think that's correct. Yes.
So we see in resolution 1, the public debt and property.
Yes.
Oh, and I should say as well, you say at slide 70 that these particular resolutions we're looking at right now, these are the ones that were going to be assigned, it was proposed to be assigned to the general legislature. That's what I've been referring to as the federal government or the
Yes.
central government.
Yes.
Okay, so if we can go back to slide 71. So the new central government was going to take over the public debt and property. Agree with that?
Yes.
And reading along from your slide deck, the regulation of trade and commerce,
Yes.
the imposition of duties, of customs on imports and exports, with some exceptions,
Yes.
the imposition and regulation of excise duties,
Yes.
the raising of money through taxation.
Yes.
Number 6, the borrowing of money on the public credit.
Yes.
Go down to 20, which is on the next page, slide 72. The new federal government was going to be in charge of banking and the issuance of paper money.
Correct.
And then in addition to all of these sort of financial things, they were also, according to 29, resolution 29, they were going to have control over Indians and lands reserved for the Indians. You agree with that?
Yes.
And would you also agree that each of these matters, that it was proposed that the central government take over, that was because they were viewed as matters of national importance.
I think that would be safe to say, yes.
Would it also be safe to say that there was this idea or this desire to have consistent treatment across the nation about these particular matters?
Yes, I think so.
Right, so I mean, we didn't want different types of banking schemes or, paper money being printed differently in each province anymore.
That's correct.
Okay. And then we get to slide 80. Two slides up. And we see resolution 60. And it says, are you there? The general government shall assume all the debts and liabilities of each province.
Yes, correct.
And we've talked a lot about that, and I think we still will. But will you agree with me that that's the resolution that was adopted and became section 111 of the British North America Act 1867?
Yes.
And then in resolution 64, that's the next slide, slide 81. This is an interesting resolution. It says, in consideration of the transfer to the General Parliament of the powers of taxation, an annual grant in aid of each province shall be made equal to 80 cents per head of the population as established by the census of 1881.
1861.
Oh, excuse me.
Yep.
1861. And you agree with me that that resolution was adopted as well? That became, I believe, section 118 of the British North America Act. Isn't that right?
Sorry, I'd have to review the number.
You can look at that. It's in your compendium at tab 1. My friend has set out the sections of the British North America Act. Oh, she hasn't set that one out. Excuse me. We can bring it up. I don't think it matters what particular
Okay.
section.
Okay.
We can bring it up
Yeah.
later, but
Yeah.
you agree with me that resolution 64 was talking about giving monies to the provinces in consideration of the transfer of their powers of taxation.
Yes, I think I did in my testimony say that by the time of the ultimate BNA Act, there was an adjustment in this, and the per capita 80-cent grant would be, in the case of New Brunswick and Nova Scotia, not fixed according to the population of 1861, but could ultimately be increased until
Yeah.
their population reached 400,000.
That's right. I remember that too. They adjust that, but they do a couple things differently. They do that, I would suggest to you. And ultimately, in the section I'm thinking of, they say that the provinces are going to have grants and the provinces are also going to have subsidies. And that is in consideration of this transfer. I would suggest to you that the federal government was now getting the powers of taxation and the provinces were getting this in exchange. Maybe we
I
can.
think that's probably safe language to use, that that this was a kind of set off, one of a number of forms of subsidy, if you like, to the provinces in consideration of the loss of taxation powers.
I think that that's accurate too. I think we'll see a bit more when we look at Galt's speech, which I'd like to turn to next.
Okay.
Could I go back to a question a minute ago? You said resolution 60 became section, did you say 111?
60, yes.
Yes,
Resolution 60 became, it was adopted as to
yes.
the extent that it was proposal, it was adopted into section 111 of the British North America Act.
Thank you.
And then you talked a bit about the speech that Galt gave to his constituents in Sherbrooke the
Yes.
month after the Quebec conference in 1864. So we're now in November 1864.
Yes.
Okay. And then now this is something that you speak about beginning at slide 83. I don't know if it would be helpful for you to have that slide up, but I have in our compendium, Ontario's compendium, included excerpts from this speech. Maybe most of the speeches. Quite remarkable. He spoke for 3 hours or so, you said,
Yes.
behind tab 1. If we could look at that. Can you let me know if you recognize this? So tab 1 is Galt's speech, please.
Yes.
And I heard you say in your testimony, I think on Friday, that this is a really valuable speech. Is that right? Do I have your evidence right?
Essentially, yes. I mean, some aspects of it, of course, this is, he's someone whose ideas about the finances were informative in terms of the Confederation arrangements. That's true. I think also, as a historian, when I assess a document or source like this, I always think of context. He's speaking to constituents. And I think part of his goal here is saying to his constituents that we're not going to be saddled by the debt of other colonies who are much worse off than ourselves. He's trying to make a case, I suppose, for confederation to his constituents. Yes.
He's a politician.
Yes, exactly so.
And in fact, you said in your report that he explained the rationale behind the Confederation resolutions. And reading from, I think it's page 52 of your report, you say that it's valuable as it contains one of the most comprehensive explanations of the financial arrangements of the Confederation plan by the statesmen whose ideas had arguably done the most to shape those arrangements.
Yes.
Does that sound familiar?
Yes.
Okay, so if we are at tab 1 and we look at a couple of different numberings, we've tried to be helpful, and we have numbering on the top right at 7. There's a heading here in the middle of the page of the right-hand column. It says the naturalization laws. Do you see that?
Well, I'll have to take your word for it. I can, yeah, now I can see
Right.
it. Yeah.
You gotta
It's,
give my,
yeah, it's very small.
I gotta give my
Yeah.
colleague a second to catch up.
Yeah, yeah.
So the naturalization laws. And the very first sentence says, the protection of the Indians and the naturalization of aliens were matters which necessarily fell to the general government.
Yes,
Now, I take aliens to be immigration matters. Would
that's
you
correct.
agree?
Yes.
And he goes on to suggest why it's helpful to attract new immigrants and settlers. But I've read this speech, and in my recollection, this is the only statement about the Indians and where that jurisdiction would lie. Do you agree with that?
I would have to review the entire speech to say that, but that would not surprise me, put it that way.
Okay. Will you agree with me that in terms of Indians and the resolution that we looked at, that a desire or that decision or proposal to give that jurisdiction to the federal government, that was codified in section 9124 of the British North America Act?
When you use the word that jurisdiction, I might assume about Indians, but maybe you have
About
something more
Indians.
specific in mind.
Yes, I mean that matters of Indian matters, to the extent that in the resolution itself, which we looked at. Find it again. The resolution at slide 72. It was proposed that Indians and lands reserved for the Indians the federal jurisdiction. And here we simply have Galt mentioning Indians in his speech. And then fast forward a few more years, and we know, I don't think it's in dispute with any of the parties, that Section 9124 of the British North America Act, Section 91, sub 24, 91, of course, being matters under the federal jurisdiction as we think of it. 24 then just simply says Indians and lands reserved for the Indians. So that proposal in the Quebec resolutions, it was accepted and it was put into the British North America Act. That's really the
Yes,
point.
exactly, yes.
And I'm just making the point that it followed along for a period of time from the Quebec resolutions through to Confederation.
Correct.
Thank you. And then I appreciate that you said that you'd have to read the speech again. I do think that it's the only reference to Indians in the entire 3-hour speech. I would suggest it's a very bold statement. Do you know, Professor Messamore, why there was no additional rationale given about Indians?
Do you mean rationale about why the topic would be placed under the control of the federal government?
Yes.
I'm sorry, so the question about this was what?
So in this speech, we see that he focuses, you said you're familiar with it. If we need to take a minute, that's fine. I thought you were familiar with it from your slide deck.
Well, yes, I mean, I read that in thousands of documents and wrote a
course.
report about it more than a year ago, yes, so.
Of course.
Yeah.
It's really focused on the finances. Would you agree with that?
I would agree that a surprising amount of the speech is focused on the finances in great detail, which I think reflects Galt's position as Minister of Finance. Yes.
And in fact, he's later recognized by some of his colleagues as it was a remarkable speech because he had it all in his head.
I think that remark was not made with respect to this speech. I think that remark was made with respect to the Confederation conferences.
I had misunderstood that then. But in any event, let's talk about, let's keep focusing on the speech for a moment. What I'd like to do is look at some of the details of it. And if we look at page 4 of the compendium, this is just really the second page of his speech.
Can that be enlarged, please?
Yeah, you could blow that up a little bit. Maybe a little bit more.
Yeah, we've lost part of
Yeah,
it
we've
though
lost
on the
part of it.
screen. I think for me, it was
Yeah.
readable at the previous.
Okay, can you go
Resolution.
back, Miriam? So- And if we can scroll down a little bit, in the middle of the page on the left-hand side, there's a heading here called or entitled "The Trade and Tonnage of the Colonies." Do you see that?
Yes, I do.
And here, I would suggest to you, he's starting to get into the financial aspects and the rationale, to use your term. And he says, let him, take it he's using himself in the third voice.
Typically, speeches were reported in that way, so he didn't use those words.
Let him avert for a moment the trade and tonnage of these provinces, because in exhibiting the amount of that trade, he would be able to bring before them in a very pointed manner the most important results which must flow from a union of all our resources. The imports of Canada, I take it he's referring there to the United Province of Canada.
That's correct.
The imports of Canada last year amounted to 45,964,000. The exports to 41,831,000. And he says together 87,795,000. See that there?
Yes.
And he goes on to talk about the different other colonies and what their amounts are.
Can I have the slide made smaller again, please, so I can
Yeah.
read the whole of that?
We'll go down a
Yeah.
bit, or zoom out a bit.
Yeah, that would be good. Yes, so yes, I would agree.
Okay. He talks about New Brunswick, he talks about Nova Scotia, Prince Edward Island. And then at the end of the information there, it's not highlighted, but at the end of the information there where he's talking about Newfoundland, there's a sentence that begins consequently. Do you see that?
Consequently, the trade of these colonies, is
Yes.
that what we're looking for? Separated as they were by hostile tariffs, preventing proper commercial intercourse between them.
Sorry, could you start that again?
Yes.
I'm not.
Unless you're just reading to yourself and then you're
Yeah,
gonna
no,
answer
I'm
the
sorry.
question.
Okay,
I can read
yeah,
it
I
out.
can, no, I've read it, yes, or.
So
can
I
read
was
it,
just
yep.
going to suggest we read it together. It
Okay.
says, consequently, the trade of these colonies, those are all the colonial provinces, separated as they were by hostile tariffs, preventing proper commercial intercourse between them, with all the disadvantages of being separated, disunited, and having necessarily smaller legislatures and smaller views on the part of their public men, amounted last year to no less a total than 137.5 millions, tells the precise terms. And he says it's a volume of trade surpassing that of almost any European country. And then there's something there that says cheers. Would
Yes,
that have meant that people would have cheered about
yes,
that?
that's what it would mean, yes.
Okay. So the colonies were sort of busy, weren't they? They had business, is that right?
Well, what he's talking about here is economic activities in the colony, and that combined, they would be a formidable economic force, I think it's safe to say.
Yeah, I think that's safe to say too.
Mhm.
And then if we go up towards the top of that page, the right-hand column, he starts talking about tonnage. And I think that relates to shipping. Is that your understanding as well?
I'll have to see the passage, but generally that phrase refers to shipping. Yes.
It's still more
yes,
economic.
Yeah, economic
Yeah.
figures, yeah.
So I'm just going to read this out. He says, now these figures were so great, so vast, that the mind required some little time before it could take them in. They represented a trade which was probably the third in the world, exceeded only by the trade of Great Britain and that of the United States, and perhaps the trade of France, which last, however, did not much, if at all, exceed the figures he had just given. You see that?
Yes, I do. Yep.
And then he said, a little hard to read, but while these two or perhaps three exceptions, no other country in the world employed the same amount of tonnage, there we have a, of seagoing craft as was employed last year by the British North American provinces in carrying on their intercourse with the world and with each other.
Okay.
And then he goes on again to talk about that this is significant. And he says that given the population rising, provinces did a large and increasing population, a vast territory, and a trade and commerce which united would vie with those of almost any other country in the world. It must be admitted there were material interests which would be greatly promoted if we could agree on a measure of such a nature as to induce the several provinces to entrust the management of their general affairs to a common government and legislature.
Yes, that's accurate. Just reading, you're reading.
And then there's a word here. I take it that's another kind of exclamation by the constituents.
That's right.
So to the extent then that Galt is providing rationale for trade and imports and exports, these were all those things that the Quebec resolutions proposed would fall under federal jurisdiction now, isn't that right?
I'm not quite sure what you mean by provide a rationale for import. Is that how you put it? I think what he's doing is he's explaining the economic strength of the colonies united together, which was part of the rationale for confederation, if that's kind of your point.
That works. I
Yeah.
took the word rationale out of your own report.
Yeah,
so I
no, it's a
was
question of
hoping to use it
rationale
again.
for what was my question.
Well, he's explaining, of course, to his constituents, and you describe in your report that in this speech, he was providing the rationale for confederation.
Yes,
Okay.
yes,
Agree with me on that?
yes.
He's setting out that it would be better to unite and have the central government controlling these things so that it would be even more advantageous to a united country. Is that right?
I think that's true. Yes.
And do you agree with me that these proposals for trade and import and exports, they were adopted into the British North America Act?
Well, these aren't proposals. This is a description of the state of things as he understands the economy at the time.
Yes. But they relate to the resolutions that we went through where he talked about the federal government having trade and commerce regulation to it. You agree with me?
Yes, so his point is that given this volume of trade, it would make sense that there aren't interior barriers to trade between the colonies, that be under the control of the central government. Yes, that is true.
And in a similar vein, the Quebec resolutions proposed that imports and exports, those very matters which are the size of a European country, they also go to the federal government. You agree with that?
Yes,
And then my next question was to you, do you also agree that those resolutions, which he's now provided a rationale for, that the resolutions ultimately were adopted? Nobody changed it when it came to the Constitution, the Confederation. They didn't stay with the province. Is that right?
yes, that is correct.
Okay, thank you. Now, if we look at, where did my speech go? We are back at tab 1 and we look at page 13. That's page 13 of the compendium. We'll need some zooming in, but on the left-hand side, is this size sufficient for you to read?
It is, although I would like to see the top of that slide so I can have the context of oh, sorry.
It's also in paper version in the compendium.
Oh, that would be better still.
I'm sorry, I
What-
thought you understood that and said it was too
I'm
small
sorry,
to read.
you did say that, of course. Yes, you did.
It is quite small. I suffer
Oh,
with it a
yeah,
bit
it's small
myself.
in the compendium. Yeah, that helps.
It
It's
doesn't
been-
help me now.
Oh.
Good luck on you.
Um,
And if it helps, Professor Messamore, I was going to point out to you that on the left-hand side of the column, there's a heading, local revenues and expenditures. I was going to suggest to you that he's now looking specifically at the provinces. And I was going to take you to the highlighted section on the right-hand column of that page. So if you have an opportunity to, as you're reviewing the context there, to think about it in that.
Yeah, so under local, I guess the reason I wanted the larger context is I wasn't sure what was meant by local, whether that was referring to the province of Canada or whether it was referring to, it seems to be referring to, we have figures for the local revenues in Nova Scotia, New Brunswick, Prince Edward Island, and Newfoundland. And I'm sorry, what was your question then?
Well, he sets those out there, but then he does go on to talk about the upper and lower Canada numbers.
Mhm.
And he does that at the bottom of the left-hand column and towards the top of the right-hand column.
Yes, I see that.
Okay.
I see the revenues,
Mhm.
the,
So
Yeah.
what I was going to take you to then is that, and you have this at your slide 100.
Mhm.
I don't think it's contentious, but I don't know if it was something that you talked about in your testimony. So I just wanted to look at it with you now. Perhaps you did, I don't remember. He says, if we can go back to the speech, he says the outlay of all of the provinces being, however, greater than their local revenues, it became necessary to make provision out of the general fund for the purpose of enabling their local legislatures to carry on the machinery of government.
yes,
And he goes on, and again, I think you have this in your slides, you certainly have
Yeah,
it
I
in your
do.
report. Goes on to say, it was proposed to take away from them every source of revenue they possessed, except minor local revenues, and then to give them from the public chest a sufficient subsidy to enable the machinery to work.
yes, that's correct.
And you agree with me that that's what we were talking about earlier? That's what actually did happen. The Constitution gave them subsidies and grants.
Yes,
And then in your report, just as a bit of a side note, to the extent that, well, it seems to suggest that this would be an exchange, you mentioned in your report that 20 years later, this was a bit of a source of discontent. Do you recall that?
yes, it was, I would say, a perennial source of discontent. Yeah, I do recall that I dealt with some examples of that discontent.
And one of them is at page 150 of your report. And you talk about what's called, I take it, the Second Quebec Conference in 1887.
Sorry,
on the
page
slide.
150, was that, you said?
I believe it's 150. It's on the
Of
screen
my
in front of you
report.
as well.
Yes, yeah, so I do refer to, when you say it's called the Second Quebec Conference, one of the things I always say to my students is that historical events don't always come with their own labels, and the label often attaches freight to it in a sense. So I think in calling it the Second Quebec Conference, the provincial premiers who organized it perhaps were trying to imply that we have a mandate to revisit the terms of confederation. I think the language is kind of significant. You might say that about Brian Mulroney's Charlottetown Accord many decades later. Yeah, I think that we can agree that the 1887 Interprovincial Conference was partly inspired by discontent over financial matters.
And you
And
quote,
can I just ask a question, Ms. Barkley, when you said this was the subject of discontent,
I mean, the
is this-
subsidies payment,
the subsidies? Thank you.
to the extent that Galt's language seems to suggest, I think Professor Messamore agreed with me that there would be an exchange in the form of subsidies for taking those revenues. They were being given these subsidies and grants. You agreed with me on that?
Yeah, various financial arrangements. I think we covered those, that the debt allowance was part of the financial arrangements, the per capita subsidy, and then the grant in aid of government, I think was.
Yeah.
how they
So
right-
the
but right-
question
sorry.
and the answer,
Hmm.
this was the subject of discontent, the concept or the numbers that were,
Well, I was referring to the line in Galt's speech that said that they would give them, because it was proposed to take away from them every source of revenue they possessed, then to give to them from the public chest a sufficient subsidy. So then I was looking at your report where, if we can go back to your report at 150, the top of the page there, the first full paragraph, we see Mercier.
Yes, Honoré
That's-
Mercier, the
He's
Premier of Quebec.
at the
Yep,
time.
yep.
And he's kind of complaining about it at this 1887 conference. Would you say that's correct?
Yes,
And-
yeah.
And you say that this is Mercier, he's explaining to Mowat, the Premier of Ontario, that Mercier had calculated that revenues for all provinces from custom and excise taxes, which had been worth $12 million at the time of Confederation, had doubled over the intervening 20 years. Then you go on in your report to say the subsidies the provinces received in exchange amounted to only 2.75 million at the time of Confederation and 3.34 million 20 years later. So Mercier is suggesting, or I suggest to you that Mercier is saying, all of these things we gave up have doubled, but what's coming into us has not doubled. Would you agree with me on that?
Yes, that was Mercier's position. I think that Mowat himself for Ontario had a slightly different agenda with respect to that 1887 conference. What I go on to say is that for Mowat, any increase in the provincial subsidies could only come at at Ontario's expense.
Mhm.
So Mercier was, for him, I would say the amount of the financial subsidies loomed large. For Mowat, his agenda concerned the federal use of the power of disallowance of provincial legislation and other concerns. And I think Mowat was concerned that if they agree to if the federal government agree to pay higher subsidies to the province, that's ultimately coming out of our pocket in Ontario.
I think
Yeah.
politicians at every conference have an agenda. I was only
Yeah.
suggesting to you that to the extent that there was supposed to be an exchange, or Galt envisioned it as some sort of exchange, certainly not everybody viewed it as an even exchange. Would you say that? Mercier certainly didn't.
I'm sorry, didn't view it as an even exchange.
Well,
You mean
20
that,
years later, it might not have been the best deal. Would you say that? Mercier thought that?
Mercier said that. Yes, I think
Is,
that's
is,
true.
can I say this? Is the subject of discontent the mechanics of the subsidies?
I would say no, Your Honor. I think the subject was really just overall dollar amounts, just feeling that they were insufficient.
Okay, the amounts
Yes,
were the subject of some discontent.
yes.
That's on both, from both Mercier and Mowat.
No, I think not for Mowat, because Mowat's concern was that if indeed provinces were given higher subsidies, we would be, I think somebody used the term cash cow or milk cow for the rest of the Dominion.
And then if we look at page 16 of the speech, and here again, there's a heading towards the bottom of the left-hand column that says the financial position of the provinces. And he talks about here on this left-hand side about the very bottom of the sentence, statement of the liabilities of Canada, and over at the top of the column, as made up by the Auditor General. And he just has this like one comment here. There's been a lot of talk the last couple of days about capitalization, and he has a comment here I wanted your thoughts on about capitalization. He says, though we were not obliged to pay the capital of that debt, particular, he's talking about the seigneurial tenure, we were obliged to pay the interest, and for the purpose of considering our position in the Confederation, it was necessary to capitalize it. You see that?
Yes, I do.
So I understood that to mean that capitalization was just sort of an accounting purpose. Do you understand that to be the case?
Well, I want to be cautious about this speech and what it means. Besides including the disclaimer that I'm not a lawyer, I
An
included the disclaimer that I'm not an accountant. And at times I find some of Galt's wording in this speech a little murky. And so I don't want to venture too far into interpretation of what he meant by this.
Okay.
And I'm looking for where we are. You say page 16?
Of
Excuse me, Your Honor,
Galt's
we're at page
speech.
16, the compendium, page 16 of tab 1.
All right.
Oh, I'm so sorry. I have misspoken. Thank you, Ms. Evans. We are at page 16 of the speech,
Right,
page 11 of the compendium. I apologize.
okay, that helps. And sorry, the question was, I don't know, about something specific. And the answer was, I'm cautious about the speech because it's murky, but
Yes.
I missed the question.
I was just
Here it is.
asking if this notion of taking these debts and capitalizing them, if Professor Messamore understood that to be a matter of accounting as they were moving forward into Confederation. But I appreciate that she said she doesn't know how much turns on it. I just
Thank you.
wondered.
Okay.
Okay. How are we doing for timing? I was going to move on to another topic. I know the court reporter asked for a break in a few minutes'
At
time.
12:45, your call.
The next topic's going to take me longer, so perhaps we break now.
All right.
Okay.
And what do we need, or what have you planned for lunch?
I understand my friends have a meeting they need to attend. So at 1:30?
We have a meeting until 1:30.
Okay.
Mr. Messamore, how much time would you like?
Oh, it doesn't matter to me.
And the court
Everybody's
reporters?
calm. Well, the question is, what do you say? 2.
2 o'clock?
There we go.
All rise. Recess until 2 p.m.